Good morning, everyone. I hope you all are doing well this morning.
Good morning.
Good morning, Your
Good
Honor.
morning.
It's right at 9 o'clock. Let me first start off calling the Orca status calendar. Everyone that's on this particular calendar they have already been on a calendar before. As such, I'm just going to call the calendar and see if we have anyone here with us. Position number 1, Roberto Arias. Roberto Arias. Given that they've been on a calendar before, does this state have a request?
Yes, Your Honor, the state will request a bench warrant.
If he doesn't show by the end of the court session today, a bench warrant will be issued. Thank you, Ms. Riley.
Thank you.
Position 2, Carlton Cuthbert. Is Mr. Cuthbert on the line with us? What's the state's pleasure?
Good morning, Your Honor. Again, a bench warrant.
Thank you. Bench warrant will be granted if Mr. Cuthbert doesn't join us by the end of the calendar this morning. Position 3, welcome. Position 3, Aquavis Jones.
Good morning, Your Honor. Mr. Jones is represented by our.
I'm here.
Okay, he's here. And the attorney for Mr. Jones is Javier Trejo. Perhaps he is joining as we speak. Well, if we may come back to this position, Your Honor.
That's fine. Good morning, Mr. Jones. We'll be back with
Good morning.
Position 4, Tara Jones. Laura Jones.
That's Tiara Jones?
Tiara Jones.
Yes, sir. Good morning. Daniel Kane for Tiara Jones.
Good morning, Mr. Kane. What are we doing with Ms. Jones this morning?
We'd like to plead not guilty and get a solicitor's name and phone number so I can contact them after today and discuss resolution.
Okay, I'm having difficulty hearing you, Mr. Kane. It's my understanding, I believe that you said that she wants to plead not guilty. Does she want a bench trial or does she want a jury trial?
We'll request a jury trial.
Okay. So what we'll do is if you'll put your information in the chat for us so that we can get you a formal request for a jury trial and we can send you a case management order, okay?
Yes, sir. And with that, may I be excused?
Yes, you have a good day, Mr.
Yes,
Kane.
sir. I also would ask that the solicitor provide her name and phone number so I can contact the proper prosecuting authority.
Okay. Who is handling position 4? Which solicitor?
Your Honor, I have that case, but this case will be moving forward to the
Division?
Judge Richardson's courtroom. So I will not be handling the case after today.
All right.
Is
So
there a solicitor assigned to Judge Richardson?
Not off the top of my head. I'm sorry, I don't. But if you want to put your information in the chat, I'm happy to go ahead and I'll find that information out for you and forward it to you.
Very good, thank you. And Your Honor, you requested that I note in the chat my request for a jury trial.
if you'll put your information in the chat, Mr. Kane, we will get you the paperwork for the official jury trial request, and we'll also send you a case management order to you at that email, okay?
Very good, thank you, sir.
All
Good day
right.
to you.
All right, have a good day. I'm going to go back to position 3. Mr. Trejo, good morning. I believe that this is your case, Marquavis Jones.
It is, Your Honor. We've received an offer from ASG Marshall Story. I'm not sure if my client is Here at the moment, if he is, I would like to just have a very brief, be placed in a breakout room with him if he is present. And actually, I do say he is present. I'd like to be placed in my client, Your Honor, and just have a brief word with him prior to making our announcement.
Let me get to the end of the calendar and I'll put you in a breakout room, okay?
Thank you.
Thank you. Position 5, Luke Marks.
Good morning, Your Honor. Wanda Gant standing in for Catrice Helen. Mr. Marks is on the line. I am asking that this case be reset to the next status calendar. As we shared with the court the last time, he was hospitalized back in August. He's recently released and we need to complete BHET.
Okay. When is our next status calendar?
November 2nd.
November 2nd work, Ms. Gant?
Yes, Your Honor. Thank you.
We'll reschedule Mr. Marks for that time. Is he on the line?
Yes, Your Honor. May he be excused?
Yes. Have a good day, Mr. Marks.
Thank you.
And what was that date?
November 2nd.
Thank you.
Position 6, Chad Owens.
Good morning, Your Honor. I do see that Mr. Owens is on the line. However, I do not see his attorney, Ms. Askew. I have relayed the paperwork to Ms. Askew. I have not received it back. So I'm not sure what we're doing today.
Okay. Good morning, Mr. Owens.
Good morning. She said that she'll be on. She's gonna log on in a second.
Okay. I'll hold for her announcement. Thank you, Mr. Owens.
Okay.
Position 7, Alan Pittman.
Recording in progress. We can bill their insurance. Use the revenue on the medical side.
And I'm sorry, is that, I can hear someone over is that in here or is that on Zoom?
She going out.
Oh, okay. I'm sorry. Alan Pittman. What's the state's pleasure?
The state is requesting a bench warrant.
If Mr. Pittman doesn't appear by the end of the calendar, a bench warrant will be issued.
Thank you.
Position 8, Tashaka Rucker.
Yes, Your Honor, this one's mine as well. I saw that Mr. Rucker is present in the chat. This is another one where at the conclusion of the first pass of the calendar, I'd ask to be put in a breakout room with Mr. Rucker, and then we'll have an announcement for the court at that time.
Okay, thank you, Mr. Trahan.
Okay, thank you.
Position 9, Richard Schneider.
Good morning, Your Honor. Steve Weiner from Mr. Snyder. He should be on. We received an offer from the state last night at 6 o'clock. I briefly discussed it with my client before 9 o'clock. I would ask the court to set, this is the first time we've been on this calendar. We had a previous time it was reset. I would ask the court to set it over to the next status calendar to give us an opportunity for my client to really consider if he wants this plea offer.
Okay, that's fine, Mr. Wonder. November 2nd work for you?
That works, Judge.
Okay, so we'll see you and Mr. Schneider back on November 2nd, and hopefully we'll get it resolved at that time.
Thank you, Judge. Good to see you.
Also, have a good day. Position 10, David Soto.
Present, Your Honor.
Yes, good morning, Mr. Soto. I have that you have attorney Miles Cohen representing you. Is that right?
Yes, sir. He said he was going to be in court and then he'll be hooking up with us as soon as he's done.
Okay, so I'll hold for his announcement, Mr. Soto.
Yes, sir. Thank you.
Thank you. Position 11, Traviant Swan. Traviant Swan, S-W-A-N-N. What's the state's pleasure?
Good morning, Your Honor. Mr. Swan was aware of this court hearing today. The state would request a bench warrant.
Good morning, Ms. Githia. If he does not show by the end of the calendar this morning, a bench warrant will be issued. He has been here before, is that right, Ms. Githia?
Yes, he appeared, I believe it was August 10th.
Okay,
And he was going to obtain a private attorney.
okay, thank you. Position 12, Michieli Verzanilla.
Judge, good morning. That's my client. How are you today, sir?
Good morning, Mr. Lewis. Good to see you.
Yes, sir. Pleasure is mine. My client and I are both present, Judge. I received an offer from Ms. ASG Githia on August the 10th. We're going to reject that offer, Judge, and ask that you place this matter on a jury trial calendar for us.
Okay, so this will be returned to the division judge. Mr. Lewis, we will send you a formal request for a jury trial and a case management order. And if you'll get that back in, we'll get the case transferred back to the division.
Yes, sir. Absolutely. And there was a communications breakup. Did you say you've already sent it?
No, we haven't. We'll send it at some point this morning. Okay.
Understood.
We have his contact information.
Yes.
Okay, we have your information, Mr. Lewis. So once you get that request, if you'll get it back to us, again, we'll get it transferred back to the division. Okay.
Thank you, sir. And if you'll permit me the day to get that to you, I've got a first appearance calendar starting at 11:30. So,
okay. No, you're
okay.
fine. You just get whenever you can get it back to us, hopefully as soon as possible. Okay.
Yes, sir. Absolutely.
Right.
Have a great day, sir.
You too. Thank you. Position 13, Kamara Woods.
This is Mike Raffoff for Ms. Woods. She's on the Zoom.
Good morning, Mr. Raffoff. What are we going to do with Ms. Woods this morning? Good morning, Ms. Woods.
We have received an offer and we're requesting a jury trial.
Okay. So we will also get either request for a formal request for a jury trial and the case management order in the matter. Do we need anything from Ms. Woods before I release her?
If I could, Ms. Woods, you need to sign some papers for us at some point. It's not an emergency, but I'm just so you'll know.
Okay. With that, Ms. Woods, you have a good day.
Okay, thank you. You all as well. Take care, Mr. Raffoff. I'll hear from you.
If you hold on, you'll have my email. I'm putting it in the chat.
Okay.
Okay.
All right. Thank you all.
All right. You have a good day, ma'am.
You too.
Let's see. That completes the Orca C calendar. Let me go ahead and I've got the final plea calendar that I'll get to, and we'll take that plea next. But, okay. Who is that?
Position 2. Position 2.
Apparently, Mr. Culberth has joined us in person. If you can come up to the podium, Mr. Culberth.
Yes.
Good morning, Mr. Culberth. I'm Judge Eric Morrow. This is the Orca C status conference calendar. Do you have a private attorney representing you, or have you made application for a public defender to represent you?
I did. Good morning. Thomas Stewart is who I'm supposed to be seeing.
Say it again.
Thomas Stewart.
Thomas Stewart?
Yes, sir.
Have you paid Mr. Stewart?
Yes, sir.
Does he know to be here this morning?
Yes, sir. He notified me. I drive tractor trailer, so I'm actually just getting back in town.
Okay. All right. So let's see. It's Mr. Stewart, Attorney Stewart, on the line with us. Okay. Mr. Culberth, if you wouldn't mind going out and giving Mr. Stewart a call and letting him know that court is in session, and let us know when he plans to join us. Okay.
Sure.
All right. Thank you, sir.
Thank you. Oh, I'll get it together.
Okay, so, Mr. Trejo, why don't we go ahead and start you in a breakout room with position 3, Mr. Jones?
Yes, sir.
Okay.
Yes, sir. That sounds
So
great.
we can put Mr. Trejo and Mr. Jones in a breakout room.
Wait, I'm sorry. This is Marqueva Jones.
Yes, Mr. Jones, I'm going to put you in a breakout room with your counsel so that you can discuss the matter, okay?
Okay, thank you.
You're welcome.
Yes, this is Travion Swan. It's just coming in. It's just now connecting.
Okay, what's your last name, sir?
Hello?
Yes, I can hear you. What's your last name?
Swan, Travion Swan.
Okay. Good morning, Mr. Swan. Let's see, you were here previous and you were requested time to obtain counsel. Have you done that?
Yes, I have. Yes, I received consultation.
Okay. Did you hire the counsel or are you proceeding pro se today?
Proceeding far as pleading to the fifth if I could.
Okay, so Mr. Swan, let me just say you have a right to remain silent. Anything we say can be used against you. You have a right to have an attorney represent you in this matter. Your case has been on my calendar previous, and I gave you the opportunity as requested by you to hire counsel. It's my understanding at the present time you do not have counsel. As such, you've been charged in case 20 CR 003856F with simple battery family violence. I'm happy to either let you speak with the solicitor this morning to put on the record what their offer is, if you wanted to plead guilty. If you don't want to accept that offer, then you have a right to have a bench trial, which would be before me sometime in the near future on this matter, or you can request a jury trial. If you request a jury trial, your case will be returned to the division judge, and the jury trial will be scheduled at some point later. Okay, so how would you like to proceed this morning, Mr. Swan?
Jury, sir.
Like a jury trial?
Yeah.
Okay. So what I'll do is we're gonna send you, do we have his information?
No, he actually had a return to sender on June 16th, so I need his current information.
Okay, we need your current information, Mr. Swan. You can you put that in the chat for us?
Yes, they should have it. I just received my court date. I gave it to you guys last time, but that's fine.
Okay, let's just get it again just to make sure that we do have the correct information. So you can either place it in the chat or you can just give it to us, whichever you prefer to do.
Okay, I'm ready for it.
Yeah, yeah.
Yes.
It's not working, so I think he needs to turn it off.
Oh, okay. The chats.
If he can.
Okay, so your chat's not working. You can't get it from the chat.
The Wi-Fi is not working. So,
Oh, okay. All
so
right.
he
So
can
we're
take it
having some
out.
difficulties here in court, Mr. Swan. So would you mind giving us that information verbally?
Yes, what do you need?
What's your address?
2670 Virginia Cove, Riverdale, Georgia 3.
Virginia, Virginia Cove, COVE.
Correct.
And where is that?
Riverdale, Georgia 30296.
30296. Is that right? Mr. Swan, give me your zip code again, please.
Yeah.
Okay, there seems to be a bit of a delay. So can you repeat the zip code?
30296.
Okay,
Email.
and your email address, sir?
That's level LEVEL Mary Nancy David at gmail.com.
Okay.
Did you get that?
Yes.
Okay. All right, thank you, Mr. Swan. You're gonna get paperwork from the court requesting a jury trial. If you can return that to us when you receive it, we'd appreciate it, okay?
Okay.
And you'll get your next court notice from the division judge to schedule your jury trial. All right?
Yes.
Do you have any other questions for me this morning?
No, that'll be it.
Okay, you have a good day, sir.
You also.
Let's see. I think I saw that. Is Mr. Cohen with us? All right, does anyone else at this, I'm gonna go on to the final plea calendar. Does anyone else need to be placed in a breakout room at this time? All right, and
Your Honor, good morning. My
yes,
name is Tashaka Rucker, and I had a late connection because I couldn't get my connection together, and I didn't know if you called my name already.
yes, yes, Ms. Rucker, you're represented by Mr. Trejo, so he's in a breakout room right now. He'll be back with us. After, at which time I'll put you into a breakout room with him so that you can discuss the matter, okay?
Oh, okay, thank you.
You're welcome, ma'am. All right, the Orca A final plea calendar, Shane Ortiz.
Your Honor, Attorney Terrence Bradley here for Mr. Ortiz. We've submitted the paperwork and we're going to accept the plea.
Okay.
We're ready at your convenience.
Okay, and let's go ahead and get that complete. See,
Your
Ms.
Honor,
Ar-
the state would be ready. I'm sorry. However, is there a court reporter present there with you in the courtroom or on Zoom? I know that Ms. Redden had requested one, but she is out on sick leave. I'm not sure if anyone was able to follow up on the request, but we would need a court reporter, Your Honor.
Do we request a court reporter? Court reporter?
Is it on the line?
Yes, Your Honor, we did request a court reporter. We did not get confirmation from Ms. Cook as to if we had procured one today.
Can we follow up on that and see if we can get someone down here to take this plea?
Yes, Your Honor.
Okay, thank you. All right, so we'll have to hold until I get a response to the court reporter.
Yes, Your Honor. I do see that Ms. Askew has joined. I'm not sure if that plea is ready.
Good morning. Good morning, Judge. Good morning.
Good morning.
How you feeling today?
Good morning, Ms. Askew. Doing well, thank you. So let's see. We're gonna have a plea on Mr. Owens this morning.
Yes, we are. And Mr. Owens has sent in his signed paperwork. Hold on one second, Judge. Hold on one second. I'm trying to bring something up, but hold on one second. Oh, Miss Raleigh has been so gracious. So we are going to accept the plea, Miss Raleigh. Did you get all the signed paperwork?
No, Attorney Askew, I have not received it yet. So
I'm
that's
sending
what
it
we're
over
waiting
to
on.
you.
Thank you.
Send it over to you, and we appreciate you, appreciate you. I'm sorry, it's early in the morning. I'm sorry.
No
But we
problem.
thank you. Very gracious, very professional. Judge, if you could give us about 5 or 10 minutes, I'll send it over to Attorney Riley.
Okay, all right, thank you. And if someone can get that to the court also, we'd appreciate it.
Yes, Your Honor, I will send it to Ms. Strong.
Okay. Mr. Trejo, do you have an announcement on Mr. Jones's matter?
Yes, Your Honor. We're going to ask that this be placed on a final plea calendar. We have some elements that my client would like to work on. I think we'd like to continue discussing with the state prior to entering a plea.
Okay, is that the November 2nd calendar?
Correct.
Okay, so does November 2nd work for you, Mr. Trejo?
It does, Your Honor. Thank you.
Okay. So we'll reset to November 2nd, and if nothing further, Mr. Jones, we'll see him back on November 2nd. Okay. And Mr. Trejo, your other client has joined us, Ms. Rucker. Would you like to be placed in the breakout room with her now?
Please, sir.
So if we can place Mr. Trejo and Ms. Rucker in a breakout room. Has I see Mr. Cohen there, but I don't, and I've seen him. Mr. Cohen, are you with us? All right, so, and Ms. Rucker, something should pop up that says join breakout room, so. Mr. Cohen, you ready for me?
Yes, Judge. I'm sorry if I disappeared. I had a call from a district attorney that I had to take, so I just moved into another room. Judge, we have a plea in this case. However, I understand the third page never made it to the district attorney and to the solicitor. And what that third page is the certification of my certification of of informing my client of the constitutional rights, city ways, and so on. And we tried to send that last night again. I don't think it worked. I could make that certification on the record. I can show the court the missing page, I think. But other than that, Ms. Githier should have the waiver and the plea paperwork.
Yes, I do have everything else except that last page.
And if it's all right with the court, I can just certify that I have, excuse me just a minute. Sorry, Judge, I have a terrier that's not mine today. And
Okay, you're fine. What, Ms. Githier, have you sent that paperwork that you have to the court?
I am sending it right now to Ms. Bolton, correct?
Yes.
I just sent it over to you.
Okay.
for some reason, I'm not finding my copies of the paperwork, Ms. Githier. So if you have them, that's good. If I have to refer to them for any reason.
I just sent them over to the litigation manager.
Okay.
Yeah.
And Judge, if I can have just 1 second, please.
Okay.
It gives you that was a circle.
Thank you, Your Honor.
All right, so is this going to be a guilty plea?
It is, Your Honor.
On the plea and verdict form, guilty is not, it's not circled. Is it all right with counsel if I go ahead and circle the guilty on the plea and verdict form?
Yes, Judge.
Anything further before we proceed?
No, Your Honor.
Ms. Githia?
Yes, Your Honor.
I'm sorry. Hold on one moment for me. Mr. Soto, good morning again. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Thank you, Mr. Soto. I apologize, Ms. Githia. Go ahead.
No problem. The state expects the evidence to show that on August 26, 2019, in Fulton County, officer responded to a person down call at 761 Sidney Marcus Boulevard in Fulton County that was called in by the Grady ambulance. Upon the officer's arrival, he spoke with Grady ambulance and they told him that they were at a light on Sidney Marcus Boulevard behind a black Acura SUV and it was not moving. They checked on the driver, which was the defendant, David Soto, and he was asleep and they were having a hard time waking him up. The offer is 12 months to serve 2 days, credit for time served 2 days, balance probated, 240 hours of community service, $600 fine, alcohol drug evaluation and treatment, and a risk reduction course.
Ms. Githia, I believe that the 240, if I'm not mistaken, comes from this being a 2nd and 10, not a 2nd and 5. Is that correct?
Second and 10.
Okay.
Yes. And the improper stopping was null prost.
Okay. Has that been null prost or do we need to get that paperwork?
It has been null prost.
Okay, thank you. Mr. Cohen?
Judge, David is ready to get rid of this and take responsibility for it. He has been ready for some time. So any delay in this matter had to do with my schedule or the courts being down or a variety of things, but he has a driver's license now. He should be able to keep his driver's license. We'd asked for an affidavit of first conviction, which I believe the court can give him in spite of the fact that it's the 1st and 10. I'm sorry, Ms. Githia.
I didn't say anything.
Okay, I'm sorry. Somebody said something. I don't think the state's opposed to that. And he would need it for his job and work and so on. So we'd ask the court for an affidavit of first conviction.
Is there any objection, Ms. Githia?
No objection, Your Honor.
May I also, Your Honor?
Mr. Soto, you have a right to remain silent. Anything you say can be used against you. If you want to speak with Mr. Cohen, I'm happy to give you that opportunity, but I don't want you to say something that might affect this matter.
No, Your Honor. It was just a drug and alcohol evaluation. I've been sober for a year, going on a year. Also, I have done therapy on it when I first started this transition. So, I'm on a new chapter in my life. So just a drug and alcohol evaluation, that was just the only thing because I have been through therapy and everything. And again, I'm going on 1 year sobriety. So, I don't want to go backwards. I want to go forwards and just get this done and as quick as possible and move on with my life. So,
Judge, I'll just say this in Mr. Soto's presence. When Ms. Githia and I negotiated this, and I believe I spoke to David about this, the evaluation does not mean necessarily that there would be treatment. Treatment is only if it's deemed necessary. So I believe, David, all the court is ordering is that you have an evaluation, and if it's deemed that you don't need any additional therapy, particularly since you've been in therapy, it wouldn't be required. Now, beyond that, Judge, I'm agnostic as to what the court does. So if the state insists on it, I'm not going to. That is what was negotiated. But
You are correct. It's a drug evaluation, alcohol and drug evaluation. And if treatment is required, then he would do treatment.
That's fine.
Okay, any other questions, Mr. Soto?
No, sir. That'll be all.
And Judge, I don't believe there was a victim impact in this. Was that intended, Ms. Githier?
There was no victim impact on this one.
Okay, good.
And the plea is, so I'm making sure that I have this right. The plea is a guilty plea to a reckless driving. Is that right?
Correct.
Anything further before I take the plea?
Which, by the way, Judge, would negate the affidavit of first conviction because he has a valid license now. He will not. He will not need an affidavit of first conviction.
Okay. Anything further? Mr. Soto, it's my understanding in case 20 CR 003787F, you wish to plead guilty to reckless driving. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
Excuse me, can you repeat that?
Yes. Has anyone forced you or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated. Mr. Soto, is there any objection by the state to once he completes the terms of the probation that it terminate? Ms. Githier?
No objection, Your Honor. Had problems getting unmuted.
Okay, you're fine, thank you. So, Mr. Soto, the sooner you get this, the terms completed, the sooner you'll be off probation. I'm going to allow the probation to terminate once you complete everything you need to do, okay?
Perfect, Your Honor. Sounds great.
All right, good luck to you, Mr. Soto.
Thank you, Your Honor. Thank you for your time.
Okay, anything further, Mr. Cohen?
No, Your Honor. Thank you very much. And thank you, Ms. Githier.
You're welcome. Have a good day.
You too.
Thank you.
Mr. Trejo, is there an announcement?
Yes, Your Honor. So my client and I were in the Zoom together and she dropped off. I asked her to give me a call and I've been trying to reach her. She was present. Obviously, we saw that she was present because we were put in the breakout room. I think the best course of action for right now, Your Honor, is just place it on that 11-2 final plea calendar. I think this is one that is going to be wrapped up by then. And then I will, I'll finish speaking to my client and we'll go from there.
Okay, that's fine. We'll place it on the November 2nd calendar.
Thank you, Your Honor.
Can someone give me an update as to the court reporter? What's going on with that?
Your Honor, we haven't heard back from Ms. Bailey. So we are working with Mr. Jordan to get a court reporter as soon as possible.
Okay, thank you.
Thank you.
Does this gentleman need attention?
Yes, he's position 1, Your Honor.
Okay. Mr. Arias, position 1, has joined us in court. Good morning, sir. Can you come up to the podium for me, please? Good morning, Mr. Arias.
Good morning.
Judge Eric Morrow. This is the Orca C status calendar. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present to represent you in this matter. Do you have a private attorney representing you on this charge?
No, sir.
Have you made application or would you like to make application to be represented by a public defender?
Your Honor.
I can't speak to the solicitor.
Okay, Ms. Gant?
Yes, Your Honor, I do apologize for interrupting. Mr. Arias applied for our services on August 10th and he did not qualify.
Okay, so as such, and have you tried to get a private attorney, Mr. Arias?
He couldn't. He said something about a contract with the county.
Okay. So you have been charged in case 20 CR 003632F with simple battery family violence. Today, I'm happy to let you speak with a solicitor for one of the solicitors to put on the record what their offer is if for a guilty plea in the matter. If you do not want to take that offer, you have the right to have a bench trial on the matter, which would be before me sometime in the near future. You also have a right to have a jury trial. If you want a jury trial, the case will be returned to the division judge and you'll get notification of that, okay? So what would you like to do this morning?
Speak to the.
Okay. Is this your case, Ms. Riley?
Yes, Your Honor.
Would you place on the record what the state's offer to resolve the matter is?
Yes, Your Honor. The state's recommendation is a plea of guilty to 12 months probation, family violence intervention program, which is a 24-week program, to have no violent contact with the victim, Nubia Sanchez.
All right, so do you understand the offer, Mr. Arias? You have any questions about it?
Could you repeat that again?
Sure, they're asking for 12 months on probation, a family violence intervention program, which is a 24-week program that you'd have to complete, and you to have no further violent contact with Ms. Sanchez, which is you shouldn't have any violent contact with her regardless. But so basically, it's a family violence intervention program, 12 months of probation. No? Okay. So now your options are, would you like a bench trial, which would be before me, or would you like to have a jury trial before a division judge?
A jury trial.
Okay, so we will get the paperwork. So if you just have a seat for us so that we can get you a request for a jury trial, and we'll get you a case management order. We'll get you to sign that, make sure that we have your proper address, and your case will be returned to the division judge, okay? You have any questions for me?
Yeah, when I asked to speak to the solicitor, well.
Okay. You want to speak, you want to call her? Is that what you're? Because the solicitor has already made her recommendation.
Oh, she made her all, okay.
That's what she was doing. So she made her recommendation.
Okay, yeah.
That came from the solicitor's office, okay?
Okay.
All right. Do you have any other questions for me?
Mm.
All right. So if you have a seat, we'll get you that paperwork and I'll get you out of here.
Okay, thank you.
Sheet and stuff like that. I want to fill it out while I'm waiting for to see if we get court.
That's fine. That's fine. Do it all at one time.
Sorry. Just 1 second.
Okay. That's fine.
Thank you.
Ms. Riley, this is Attorney Askew. Can you confirm that you've received my email, ma'am?
Good morning. I was just sending you an email. I have not received it yet.
It should be coming. You may have to refresh.
Okay, I will try that.
Yes, ma'am.
Thank you.
So basically, this is not an order that you want to request a jury trial. We just have to fill this out. Representing yourself or getting counsel, you just have to read these options. So you're requesting a jury trial.
Ms. Riley,
Are you gonna plead not guilty?
while we have a moment, who's handling the 11:30 defendant plea and bar in the Mendoza matter for the state?
I'm sorry, I didn't hear what you said, Your Honor.
I believe 11:30 is Ms. Gibeah, Your Honor, and
Okay.
Mr. Patterson.
Yes.
Okay, I just wanted to know. And what about the any updates on the 1:30 jury trial bench trial calendars?
Yes, Your Honor, I believe that 5 are moving forward. I know one of mine has already been removed to the 11:23 bench trial calendar, but myself and Mr. Patterson will be there for the 2 that I have left on the calendar, Ms. Awanyu and Mr. I think it's Jarrell, Mr. Combs.
And Quadravius Rucker is also moving forward on the bench trial calendar at 1:30.
Okay, thank you. Just wanted to get a handle on what was happening this afternoon, so thank you.
And Ms. Kiara White and Robert Willis are also going forward, Your Honor.
Okay.
And Ms. Attorney Askew, I do have the paperwork now. I'm sending that to Ms. Bolton.
Yes, ma'am. Thank you so much. Attorney Riley.
You're welcome.
Okay.
Get ready for my first.
My client's not. Okay. Mr. Stewart?
Yes, sir.
Good morning. How are you?
I'm fine, sir.
Good. What are we going to do with Mr. Colbert today? You're fine. You're fine.
I'm getting old, sir. Be perfectly honest, I'm not quite sure. This was his son, and his son does not want to press any charges, so that's why we're trying to figure out what's going on.
Okay. Would you like to speak with the solicitor in the matter?
Yes, sir. How to do that?
Okay. On position number 2, Carlton Colbert. Whose case is this?
Yes, Your Honor, that would be my case, Ms. Riley.
So I'm going to have Mr. Stewart call you so that you all can discuss. He's in court with me right now, so that you all can discuss that matter. And I don't know how you want to do it. Do you want to call Ms. Riley?
Yes, sir. I can get it right here if that's not a problem.
Well, if you were here, then I don't know if we're able to put you into a breakout room, and then you'd also not have any privacy. So if you wouldn't mind stepping out and giving her a call to discuss it with her. Do you have a phone number?
I need her phone number, sir.
Can you put your number in the chat, Ms. Riley, and we'll get it to him?
Yes, Your Honor. Would I send it to Ms. Bolton or?
She can just give it to me now.
You can just send it to me. Can you send it to me and I'll write it down for him?
Yes, Your Honor. But Your Honor, I also believe that we should be almost ready to go on the plea for Mr. Owens. So I don't know if you want me to speak with Mr. Stewart first or do the plea, Your Honor.
So why don't you go ahead and speak with him and we'll hold. So if you'll go out and call her right now.
Yes, sir.
And we'll take the plea when you get back, Ms. Riley. Okay?
Thank you.
Mr. Arias, you want to come back up? So I just want to make sure that, let's see, yes, that you understand what's going on, okay? So you have been charged in case 20 CR 003632F with simple battery family violence, okay? This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. All right. So it is incumbent upon the state to present evidence to the court or to the jury to prove beyond a reasonable doubt that you're guilty of this violation. So they will bring, and you've requested a jury trial, they will bring whatever witnesses that they have in regards to this matter and present to the jury. You also have the right to have a defense. You have a right to remain silent, but you also have a right to testify. You also have a right to present evidence if you wish in regard to this matter. You don't have to do anything. It's up to the state to prove the matter. So you either have a right, so you've requested a jury trial, which means that there will be a jury and panel to decide whether or not you're guilty of this violation, okay? So that's what you requested earlier. You also have a right to have a bench trial that would be in this courtroom with the solicitor. They'd have to make the same presentation, but it would just be before me. And I will make the determination as to whether you're guilty or not. And I will make the determination of what, if you are found to be guilty, what the sentence will be. Okay, does that help clarify for you what's happening? Okay, does that help you at all with making a determination as to how you would like to proceed? If you still want to proceed with the jury trial, that's your right. You want to take a moment to decide, or you have any questions for me, or?
He said I could show my proof
if you don't have to present any evidence, but if you wish to present evidence in your defense, you have a right to, to present any evidence that you want to present to the court.
Does that mean the other person or?
Whatever evidence that you have. But understand it's up to the state to prove that that you committed this offense. So they would have to present witnesses, and they would have to present whatever evidence they have in this regard. You have a right to cross-examine their witnesses or challenge whatever evidence that they have.
Okay.
Okay. So you still like to proceed with a jury trial in the matter? Okay. Any other questions for me? Okay. Ms. Bolton? So has he signed everything?
If he's requesting a jury trial, no, he needs to specify on the sheet.
Okay, so let's get him to do that, and then you're good to go. Okay, okay. Thank you.
All this information is correct. That's your address. That's all it is. Okay. We're gonna take out a jury trial right here. You gonna hire your attorney or represent yourself? You gonna try to hire your attorney? Okay. This sign right here. Right, so here's your copy. Make sure your information is valid so they can get in contact with you. But if you are here, if you need family paperwork for her, you need to email her. That's the assigned litigation manager. So she does the same job I do, but it's for the assigned division. Mine too.
All right, is there an announcement, Mr. Stewart?
Yes, sir. We have come up with an agreement. It's gonna be amended to a disorderly conduct, $200 fine, 3 anger management classes, and an evaluation for alcohol and substance abuse. Now, the problem, of course, is that the clerk would have to amend it. So I would have to come back at another time to do that. My client is an over-the-road truck driver. I was wondering if we could just do a plea of abstention once the state has it ready, and then I can come in and enter the plea. Would that be okay with the court?
That's fine with the court. Ms. Riley, do you have any objection to that?
She said she didn't have any, but I don't know what's going on now.
All right. I don't know if she can hear me. Ms. Riley. Can anyone hear me? Yes? Okay, thank you.
Yes, I can hear you.
Yes, Judge, we can hear you.
Okay, thank you.
She's there, just.
Ms. Riley, can you hear me? Okay. If you say that.
That judge is calling you. You can't hear him?
Oh, no.
Oh. You're still on mute, Ms. Riley.
Thank you. Sorry about that.
That's
I
all
have
right.
my computer on mute so I could talk to Mr. Stewart.
Okay, that's fine, Ms. Riley. Let's see. The state has no objection to a plea and abstention, is that correct?
No, Your Honor, as long as the court is fine with the plea and abstention, I still have to amend the accusation, which I explained to Mr. Stewart could not be done today because the clerk's office would then have to enter that before we would get the paperwork. So I will do that amendment and get him the plea and abstention paperwork, but I would need Mr. Stewart's email address if he could provide that.
Okay.
Yeah, can you hear me?
Yes, I can hear you.
F is in Frank. O as in Oscar. P as in Paul. E as in Echo. S as in Sierra. Q as in Quebec at AOL.com.
Okay, let me just repeat that. F is in Frank, O as in Oscar, P as in Peter, E as in Edward, S as in Sam, Q as in Quebec at AOL.com.
Yes, ma'am.
Okay.
All right. Does November 2nd work for you, Mr. Stewart?
Yes, sir. If we can do it early, I would appreciate it.
Do we have anything earlier?
One moment, Your Honor.
Well, Your Honor, I believe what would happen is that once Mr. Stewart receives the paperwork, he and his client would sign it and send the money. And once that's received by the court, if that's done before November 2nd, that would dispose of the matter. They don't have to return to court.
Okay, so if we get it by November 2nd, we're good to go.
Yes, sir. If I get it tomorrow, it'll be done tomorrow.
All right, very good. Anything further, Mr. Stewart?
No, sir.
All right, you have a good day.
Thank you, sir.
Yes, sir. Thank you, sir.
Thank you, Ms. Riley.
Thank you.
Okay, are we ready for Mr. Owens's plea?
Yes, the state would be ready, Your Honor.
Ms. Askew?
Good morning, Judge. I'm sorry. I'm actually with Judge Williams in Superior Court on her 9 o'clock Zoom. I'm just making an announcement. Can you guys give me about 10 minutes? It's just a status hearing. She just called my case.
Okay, all right. Let us know when you're ready.
Yes.
Okay, so we're holding on that matter, and we're also still trying to obtain a court reporter.
Your Honor, if possible, may I please be placed into a breakout room with the person listed on the screen as Deborah?
Okay. Can we place Ms. Riley and Deborah in a breakout room, please?
Thank you, Your Honor.
Your Honor.
Yes, Ms. Githia. Oh, there we go. Hi, Ms. Greenhouse.
Good morning, Judge Morrow.
Good morning. Thank you for being able to assist us on such short notice. We appreciate it.
Absolutely. You're welcome. Glad to be here.
Oh, Judge Morrow, I got a message saying that Alan Pittman is on the Zoom. He's position 7. Looks like it might be under iPhone.
Okay. Mr. Pittman, can you hear me?
Yes, sir, I can.
All right. Good morning, Mr. Pittman.
How are you?
Let's see. I'm doing fine. You're gonna have to get yourself to a steady state so you can speak with the court. Okay.
I'm sorry.
All right. So, Mr. Pittman, let's see. You've been charged with criminal trespass and damage to property. Do you have an attorney representing you on this matter?
I don't.
Have you sought to make application with the public defender to see if they can represent you on this?
I did. They weren't able to.
Okay, so let me just say that you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. It's my understanding that you don't qualify for the services of the public defender. As such, you'll have to proceed pro se today regarding this matter. You've been charged in case 20 CR 004110F with criminal trespass and damage to property. I'm happy to let you speak with the solicitor so that they can put on the record what they would ask for a guilty plea in the matter. If you're not satisfied with what they offer you, you still have the right to have a bench trial, which will be before me sometime in the near future, or you have the right to have a jury trial. If you would like a jury trial, the case will be returned to the division judge and you get notification of a future date for that jury trial. How would you like to proceed this morning?
I'll take the offer.
Okay, well, you might want to hear the offer before you decide to take it, okay?
Well, yeah, I'm sorry, I want to hear it. I'm sorry.
All right, you're fine. Ms. Marshall-Story, is this your case?
Yes, Your Honor. The offer is on a plea to the criminal trespass. The defendant would need to accept 12 months of probation and complete the domestic violence intervention program and have no further contact with Brian Burns.
Okay, do you have any questions, Mr. Pittman, regarding that offer? Mr. Pittman?
Yeah, about the probation, is it something like a fee every month, or is it like a fine that I could just pay?
No, they're requesting a domestic violence intervention program, which is a program that you'd have to complete while you're on probation. Once you completed the program, the probation can either terminate or it can go to a non-reporting status.
Yes, the state has no objection to that, Mr. Burns. I'm sorry, Mr. Pittman.
Okay, no, I'll accept it.
And there's no further contact with the alleged victim in the case. Okay.
Oh, okay.
All right. So we would have to get you. Do you have a way to receive paperwork?
Yes.
You do.
Hmm?
Do you have a way to receive?
You talking about right now, this moment?
Yes.
No. I could send my email if you could email it to me.
All right. So what I'm going to do, Mr. Pittman, is I'm going to put you in touch with Ms. Marshall-Story so that you all can get the paperwork together so that next time you come back to court, we'll just take the plea. Okay.
Okay.
All right, so that it's gonna be November 2nd. Ms. Marshall Stewart, would you mind putting your contact information in the chat if you've not already done that?
I will do that right now, Your Honor. And Mr. Pittman, I'm going to forward you, well, I need you to reach out to me, or you can send me your email address, and I'm going to forward you the plea paperwork. Please read it, review it, and you can contact me via email if you have any questions about it, and you'll need to sign it and return it back to me in advance of the court date that the judge is going to give us.
Okay.
Okay, thank you, sir.
All right, and so that date is gonna be that November 2nd date. Let's see, Ms. Bolton, do we have his correct contact information?
One moment, Your Honor. If you could just, excuse me, verify his first 4 digits for his address.
It's 3095.
Yes?
Yes.
Okay, we have it, okay?
Okay.
Any other questions this morning, Mr. Pittman?
No, that'll be it.
Mr. Pittman, look in the chat and you'll see my email address.
Okay, thank you.
You're quite welcome.
Okay. Have a good day, sir.
You too.
All right, are we ready on Mr. Ortiz?
Yes, Your Honor, the statement is
Judge.
ready.
Yes, Judge. Defense is ready.
Okay, so we have Ms. Greenhouse on the line to take down the plea. And Mr. Ortiz, if you can unmute yourself and raise your right hand for me.
Good morning.
Good morning again, sir. Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can put your hand down. Thank you, sir. Ms. Riley?
Yes, Your Honor. The state would expect the evidence to show that on June 28th, 2019 in Fulton County, near 3700 MLK, that Mr. Ortiz fell asleep while driving and ran a red light while driving a delivery truck and T-boned the vehicle carrying Miss Darlene Jones. Miss Jones was a month shy from her 80th birthday and was being driven by her caretaker who suffered non-life-threatening injuries. The investigation revealed that Mr. Ortiz never applied the brakes prior to impact. Mr. Ortiz has an extensive driving history or criminal/driving history. In 2005, there was a school suspension for driving. 2006, following too closely. 2007, he had a suspended license. Actually, 2 in 2007, 2 suspended licenses. 2008, there was a speeding. 2014, false statements. I believe that may still be pending. Also in 2014, a offense for controlled substance or possession of a controlled substance. In 2015, possession of marijuana. 2017, failure to yield. 2018, a center lane violation. In 2018, speeding. Most of these violations, Your Honor, happened in Cobb County. I do have Ms. Jones's next of kin on the line, Ms. Deborah Brune and Mr. Doug Jones, who is on Zoom as owner. And I believe they would both like to make victim impact statements. Would you like for them to make the statements prior to me giving the state's recommendation or after, Your Honor?
It's up to you, Ms. Riley. I'm happy to hear the statements at the present time if that's how you'd like to proceed.
Yes, Your Honor.
Okay,
And-
so who would like to speak first?
Ms. Broom, you're still on mute.
Okay, can you hear me?
Thank you. Yes, we can hear you now.
Okay, I'm going to speak for my brother and myself and our family.
Okay, yes, ma'am, go ahead.
Sorry. Our
Take your
mother
time.
was so excited about her 90th birthday that she would celebrate along with her son's 65th birthday, which were 3 days apart. We had a family barbecue plan that included her children, their spouses, grandchildren, and great-grandchildren. And then a big 90th birthday party was planned with friends and family the next day. She had tried on her party clothes and was so happy and looked so cute. She always looked stylish. No old lady clothes for her. That was the last time we saw her before the accident. The next time we saw her, she was in a coma with her body broken and beyond repair. Her life was taken senselessly 3 weeks before her 90th birthday. A vibrant woman who played bridge several times a week, belonged to a book club, took Tai Chi, and had her hair done weekly. Invitations had been sent, and when friends happily called to respond, they had to be told what had happened through tears. It was agonizing and hard to get the words out. So instead of having a fun, happy, celebratory 90th birthday, we had to plan a funeral. Our hearts are broken, and we will never see our mother again because of the decisions Mr. Ortiz made that day. He took away a kind, sweet person, our mother, who was also a loving grandmother and great-grandmother. She brought joy and happiness to her great-granddaughter, and she never got to know there are now more great-grandchildren that will never get to know her. Mr. Ortiz should take responsibility for his actions and suffer the consequences for taking her life. We miss her. We all miss her. I'm done.
Okay. Thank you, ma'am. Ms.
Thank
Riley?
you. Thank you, Ms. Broom and Mr. Jonathan. Again, I'm deeply apologize for your loss. You have my sincere sympathy. And to perfect the record, Your Honor, I believe I said 80th birthday. It should be 90th birthday. The state's recommendation for, I believe it's either count 1 or count 2. It's listed here as count 2, but it should be count 1. The homicide by vehicle is 12 months to serve 30 days. Balance on probation, a $1,000 fine, 240 hours of community service. He is to attend 1 defensive driving course, and it has to be certified by Department of Driving Services. He is to attend 2 victim impact panels. Count 2 or count 1, the failure to obey traffic signs and signals, will merge with the homicide by vehicle count. Count 3 is 30 days to serve concurrent to the homicide by vehicle count.
And what is count 3?
Count 3 is the driving without proper class of license.
Okay.
Okay. Count 4, the expired or no license plate or decal, is 12 months probation consecutive to the homicide by vehicle count. Count 5 which is the expired tag or unregistered vehicle, is 12 months probation consecutive to count 4. Count 6 is 12 months probation concurrent to the homicide by vehicle count.
What is count 6?
Count 6 is the defective or missing speedometer, excuse me. Count 7, which is defective tires, is 12 months probation concurrent to count 4. And count 8, which is the defective windshield or windshield wipers, is 12 months probation concurrent to count 4. The I believe it's driving with a proper license. So to recap, Your Honor, it is 36 months to serve 30 days. Mr. Ortiz is to receive credit for any time served upon arrest. The balance of the 36 months on probation will be on probation, excuse me, a $1,000 fine, 240 hours of community service, 1 defensive driving course, which is certified by the Department of Driving Services, 2 victim impact panels, and 24 months of the probation may be suspended upon successful completion of all of the terms and conditions within the first 12 months.
All right, so do we know how much time has already been served, Ms. Riley?
Your Honor, I do not have the total amount of time that has been served.
Okay.
But I
And it's my understanding that he is going to plead guilty to every charge that's listed except for the failure to obey traffic signs, signals, and markings.
Yes, Your Honor.
Ms. Strong, did you get the information that you needed?
I do. I think Mr. Jordan was right.
Okay. All right. Anything further, Ms. Riley?
Nothing further from the state.
Thank you. Mr. Bradley?
Yes, Judge.
Yes. Anything from you, sir?
Yes, Judge. First of all, I'd like to give our sincere apologies and condolences to the family. My client has always wanted to reach out. However, due to the nature of civil suits and things like that, he was not able to do that, Judge. We accept the plea as negotiated. This happened 3 years ago. My client has completed all terms of probation. He's done the DUI school, he's done the MAD impact panel, he's done community service. He may need a little time to pay the fine. He tried to take responsibility in Sandy Springs. We went before that court to take a plea and was told that it couldn't be handled in Sandy Springs, only to find out just a few days ago that now it could be handled in Sandy Springs. But he tried to take responsibility over 3 years ago, Judge. He was not prolonging this. This is essentially the same terms that he tried to take responsibility for 3 years ago. He's completed everything, and we've just asked the court to accept the plea as negotiated. He will need a turn-in date to turn himself in, and he wants to get this put behind.
Okay. When does he want to turn himself in?
Mr. Ortiz, when can you turn yourself in?
If 2 weeks will be fine.
I don't have a calendar. Say it again. And that's Wednesday, October 12th. Two weeks is Wednesday, October 12th. I'll say it that way. Is that the date that's requested?
Yes, please.
Mr. Ortiz, okay. All right.
Any objection, Ms. Riley?
Your Honor, I know standard is normally within a week of taking the plea. If there are some extenuating circumstances as to why it would be 2 weeks for a turn-in, I would certainly, reconsider my objection if there are some extenuating circumstances for a 2-week turn-in.
Mr. Ortiz, is there a reason that you want to put it off for two weeks?
Yes, because I do landscaping and I have contracts with people for the remainder of the year, and I have to have time to find somebody that can take over my contracts for me, so I won't lose them.
Okay.
Understood. Well, with that explanation, Your Honor, the state would withdraw the objection.
All right. So you're to turn yourself in on October 12th by 6 p.m. Okay.
Okay.
All right. Anything further before I take the plea?
Nothing further.
Nothing from the defense. Sorry, Judge.
Ms. Brune or Mr. Jones, if you have anything else that you would like for the court to know. But if not, nothing else from the state, Your Honor.
Okay.
Thank you.
Mr. Ortiz, I believe that you've already been sworn in. It's my understanding that in case 20 CR 001804F, you wish to plead guilty to homicide by vehicle in the second degree, driving without the proper class of license, expired or no license, plate or decal, expired tag or unregistered vehicle, defective or missing speedometer, defective tires, and defective windshield or wipers. Is that correct?
So this we can put. Yes, sir.
You under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
You had the opportunity to go over with your counsel the guilty plea statement. Is that right?
Yes, sir.
And you signed that, you initialed and signed that paperwork. Is that correct?
Yes, sir.
Did anyone force or coerce you to plead guilty to these charges?
No, sir.
I am going to accept the plea as negotiated. Again, you have to turn yourself in by 6 p.m. On that date that we discussed. And it's my understanding that although you have done quite a bit of the requirements that will have you on probation, as long as everything is done by within the 36 months, 24 months will be suspended. Is that correct, Ms. Riley?
Your Honor, just one brief correction. If it's done within the first 12 months, 24 months will be suspended. Yes, sir.
Okay. Thank you.
You're
All right. You understand that, Mr. Ortiz?
Yes, sir.
All right. Anything further? Mr. Bradley, Ms. Riley?
Nothing from the state, Your Honor.
Nothing from the defense, Judge.
All right. Ms. Deborah and Ms. Broom and Mr. Jones, the court is so very sorry for your loss. We appreciate you being here today. And Mr. Ortiz, good luck to you also. Okay.
Thank you, sir.
And Judge, will we get the paperwork so that he can at least take the paperwork with him to Rice Street in case there's for some reason they don't take him in on the 6th. I've seen that happen.
Okay,
But can we provide the paperwork?
Yeah, we're happy to provide you the paperwork, Mr. Bradley. We'll get it to you, okay?
Thank you, Judge.
Okay, and if we don't, just follow up. I'm instructing the clerk to do that. But if you don't get it in the very near future, follow up with us, okay?
Thank you, Judge.
All right, you all have a good day. Thank you.
Judge Morrow, do the defense counsel know what the critical time served is? He didn't spend time in the Fulton County Jail.
Mr. Bradley, do you know how much time it's been served?
I do not, Judge. As I said, this is over 3 years ago, but it was he was in Sandy Springs, and I think it was only it may have been the same day, but if they.
Excuse me, I never been arrested for this. It was just a ticket.
Okay, so there's no credit for time served. It's my understanding, and so he'll. All right. So thank you, Mr. Ortiz. We appreciate you letting us know that.
All right, no
Thank you,
problem.
Judge.
Thank you.
You all have a good day. Ms. Greenhouse, thank you very much. We appreciate you joining the court on such short notice. Thank you.
In your honor, may Ms. Bruin and Mr. Jones be excused.
Yes, you all have a good day as well. Thank you for being here.
Thank you.
They deserve to have.
Judge. Judge Williams is just speaking to my clients now. If you hear her in the background, she's about to release us.
Okay, all right. So just let us know when you're ready, Ms. Askew.
Thank you.
You're welcome. Mr. Riley, I'm sorry, would you tell me again who is handling the 1130 Mendoza motion?
Certainly, your honor, that would be ASG Gideaya and Mr. Patterson.
Okay, and did you all have, I know that I have the motion from Mr. Mendoza. Did you all have anything written that you wanted me to consider, Ms. Gideaya?
It's going to actually be a negotiated plea, Your Honor, and
okay.
Mr. Patterson has the plea paperwork.
Okay, that's even better. So I don't have to to worry about this. You should have told me that first. Okay, all right. We'll be in recess until Ms. Askew is ready.
Thank you, your honor.
Would you all like to go over the 9 o'clock calendars while we're waiting so we can get that done?
Yes, that would be fine with me, Your Honor.
Yes, that's fine.
Good morning. Can everyone hear me?
Yes.
Yes.
Okay. All right, I'm back with you all. My apologies, but thank you for your patience. We're ready.
Judge, I'm ready. Attorney Askew.
Okay, all right. So we'll go ahead and take the plea and then we'll do the thing. Okay.
I'm so sorry, Judge. Thank you for your patience.
No, that's not a problem whatsoever. Let's see. This is Mr. Owens, and he is pleading no to 1 count of battery. Is that correct?
Yes, sir.
Yes, Your Honor.
All right. Good morning again, Mr. Owens. If you can unmute yourself for me. Hey, good morning. Raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Riley?
Yes, Your Honor. The state would expect the evidence to show that on February 23rd, 2019, officers were dispatched to 7915 Sonoya Road, Fairburn, Fulton County, in reference to a physical altercation. They made contact with Mr. Chad Owens, who stated that he and Rosalind Theodore were that Theodore or Rosalind Theodore was trying to fight him in the residence. They then spoke with Miss Theodore, who stated that she had been slapped in the face, and there was a mark on her right cheek. The state's recommendation, Your Honor. Give me just 1 second. Is 12 months to serve 24 hours credit for time served upon arrest, so no additional time to be served. The balance on probation, a family violence intervention program, and he is to have no violent or harassing contact with the victim, Rosalind Theodore.
Counts 2 and 3 are, or have they already been null pros?
They have not, Your Honor. They will be null pros. I will send the null pros to Ms. Bolton.
Okay, thank you.
You're welcome.
Ms. Askew?
Hello, Judge. This is an older case, Judge. I'm very familiar with the case as I represented Mr. Owens in a divorce case. The alleged victim, the mother, she was pro se at the time. My client has 50-50 custody of their daughter. To my understanding, Your Honor, after 3 or 4 years, the parties get along. He's fine with everything. He just wants this matter resolved. My client has never, ever been in trouble before, except for this one time. He's never had to serve any jail time, except for this one time. And, he's just ready to get it resolved. He agrees that he will not have any violent contact. He's in a position now, Judge, that he will likely will only want to communicate with her via email and via text. But from what I understand from Mr. Owens, they co-parent well. This little girl is thriving. She's with, her dad 50% of the time, with mom 50% of the time. He just wants to move on. He owns his own painting business. He's well known in the community. It's just a darn good person. He apologizes for the time that he's taken up with the court. He just wants to move on with his life, Judge.
Okay, thank you. Mr. Owens, it's my understanding that in case 20 CR 004108F, you wish to plead nolo contendere to battery. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading nolo to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead nolo?
No.
I'll accept the no-low plea as negotiated. Is there any objection to, once the terms probation have been fulfilled, that probation terminate?
No objection from the state.
So the sooner you get this, all the terms done, Mr. Owens, the sooner you won't be on probation. I'm gonna allow the probation to terminate once you complete the terms, okay?
Thank you, Your Honor.
Just one question. Can he go non-reporting on probation? Would the state have any objection to that, or the court?
No, Your Honor. I mean, essentially, it's the same thing. He would actually be on probation longer if it's non-reporting, because it wouldn't terminate upon completion. So, but that's up to Mr. Owens.
The shortest time, I guess he can speak to probation, the shortest, that's fine.
Okay.
I get you, Ms. Riley.
Okay.
All right. Good luck to you, Mr. Owens.
Thank you.
Thank you, Mr. Owens. Thank you, Ms. Attorney Riley. Thank you, Judge. I appreciate y'all.
All right, y'all have a good day.
Thank you.
Thank you.
Ms. Gann, are you there?
Yes, Your Honor.
In regards to your question, it's my understanding that the bench trials are only going to be in person, so they're not going to be on Zoom this afternoon. So we're happy for you to join us, but you'll have to come to G33.
Okay.
Are you there?
Thank you, Your Honor.
All right. And as soon as Ms. Bolton's ready, we will go over the calendar.
Good morning. Is everybody ready?
Yes.
Yes.
Thank you. Okay, position, this is Orca C status calendar. Position 1, jury trial requested. Position 2, reset 11-2. Position 3, reset 11-2. Position 4, jury trial request. Position 5, reset 11-2. Position 6 was a plea. Position 7, reset 11-2. Position 8, reset 11-2. Position 9, reset 11-2. Position 10 was a plea. Position 11, jury trial requested. Position 12, jury trial requested. Position 13, jury trial requested. Any questions? All right, thank you.
Okay, so we will be in recess until 11:30.
Thank you, Your Honor.
Your Honor, it's the same Zoom link for the motions calendar, correct?
Is that correct? Yes, I think so.
Okay, thank you.
But I'm not going to shut down, so you can just come right back in.
Okay.
Okay.
Step outside.
Your Honor, I apologize. Are you still there? Or is anyone from court? Support from the litigation managers? Anyone still in the courtroom?
The judge stepped off the bench. Did you need something?
Hey, who am I speaking to?
This is Michael.
Hi, Mr. Jordan. Quick question.
Yes.
Judge Morrow mentioned that Zoom won't be active for the 1:30 bench trials, but will there be a court reporter available in the courtroom? We have to have some kind of record.
Let me check on that to make sure they ordered a court reporter. Are y'all having any jail time, please, for the bench trials?
Well, no, they're just their actual trials, so we would want those taken down.
Okay, let me check to make sure we can get a court reporter then.
According to, one second. According to, I'm sorry. Ms. James requested a court reporter yesterday.
Oh, so they did request a court reporter, so I'll check with Ms. Bailey
Were
to
you
make
doing
sure
bench trial?
one is going to be in here.
I have 3.
Okay, I just wanted to make sure that we were covered. If we're not going to be on Zoom, but we have to have some kind of record. So,
Okay.
Okay.
Is there a problem with the Zoom link being activated, or do we just need to go to YouTube?
We don't use a Zoom link.
So there was no Zoom link created for the bench trial counts because it was supposed to be an in-person count.
Oh, okay. We had one previously and it was on Zoom. So I thought it would follow the same protocol.
No, I think so everyone was supposed to be in the courtroom, but because everyone didn't show up in the courtroom, that's why she opened up the Zoom link. But it's technically everybody's supposed to be in the courtroom for the bench trials.
Also, if we have a court reporter, they are permitted to be on Zoom.
That's up to the judge.
Yeah, I guess so.
If we can't get a court reporter, is it okay if they do it on the Zoom? Okay, so the judge wanted everyone to be in the courtroom, so I'll have to make some quick phone calls and I'll have to let everybody know.
Okay. Just trying to make sure it's clear because I know some, people who like Ms. Marshall's story who does not have a bench trial, but would still want to view them and be available to assist us.
Okay.
At in person, would like to be on Zoom. So if that's possible, that would be helpful.
Yeah, so we can still run the Zoom link. That's fine. I'm guessing it'll be the same one that y'all using now.
Okay.
Okay.
Thank you.
Thank
You're
you.
welcome.
Who do we have on from the state and the Mendoza matter? Is that you, Ms. Githia?
Yes, Your Honor.
All right. And it's my understanding that this is going to be a plea.
Yes, he signed up, Your Honor.
Okay, so if you want to have him come up to
Podium? Yes, sir. Come on up, please.
All right, good morning, Mr. Mendoza. I'm Judge Eric Morrow. Can you raise your right hand for me, please? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Yes, Your Honor. Okay, and we have this being taken down by a court reporter. Could counsel, for the record, please, you can put your hand down, Mr. Mendoza. Please give your names.
Special Prosecutor Jackie Jackson for the state.
And Your Honor, my name is Eli Bennett. I represent Mr. Mendoza.
Okay.
Let me have again, Your Honor.
Yes.
Mr. Mendoza, are you here today to enter a plea on this case?
I am.
And what is your full name?
Luis Giovanni Mendoza Gutierrez.
And Counselor, can you state your name for the record?
Yes, sir. My name is Eli Bennett, spelled Bennett.
Okay. And sir, you understand that you have a right to a trial. And you have a right to a jury trial or a bench trial based upon your choice.
Make sure you verbalize the answer, yes or no.
Yes, sir.
Okay. And you understand that you have the presumption of innocence in this case.
Yes, sir.
And that you have a right to a speedy and public trial.
Yes, sir.
You have the right to see, hear, and cross-examine all witnesses testify against you.
Yes, sir.
Wait,
I don't understand.
So we can hear you.
Yeah, it's fine.
You
Don't
gotta
worry
speak
about it.
up because it's being taken down.
Oh, sorry about that.
Okay. You understand you have the right to compel production of evidence and the presence of witnesses in your favor.
Yes, sir.
You understand that you have the right to an attorney, and if you cannot afford one will be appointed.
Yes, sir.
You understand that you have the right to remain silent and not testify against yourself.
Yes, sir.
You understand that you have the right to make the state prove this case beyond a reasonable doubt.
Yes, sir.
I can't hear.
Oh, yes, sir. Sorry about that.
Yeah, don't be nervous. You can stand a little closer to the microphone if that helps a little bit.
And has anyone told you that you'll receive a lesser sentence other than the plea that's been negotiated?
No, sir.
Has anybody promised you anything to enter this plea?
No, sir.
Are you doing this freely and voluntarily?
Yes, sir.
You understand that the recommendation is that your DUI is being reduced to reckless driving, and that the other two charges, hit and run and reckless driving, the DUI is being reduced to reckless, and the hit and run is being dismissed.
Yes, sir.
Okay. Has anybody promised you anything other than 12 months to serve, 24 hours credit for time served, balance probated, 40 hours community service, $300 fine, drug and alcohol evaluation, risk reduction, and that we are agreeing to, once you finish all of those terms, you can go non-reporting, but you'll still be on probation. It'll just be non-reporting.
Okay, yes, sir. I understand.
And counsel, do you stipulate that there's a factual basis for it?
Yes, we do.
None of the defendant is here to tender a no plea to a reckless driving. Yeah, folks with the forms.
Yes, thank you. So it's my understanding, Mr. Mendoza, that you wish to plead no low to reckless driving. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Greatly.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Sure.
You don't want a trial by jury, do you?
I don't understand quite. Can you,
So if you enter a plea, then you're waiving your right to a trial by jury. You have a
Okay.
right to a trial by jury, but if you enter a plea on this charge, you won't be getting a jury trial. Do you understand that?
yeah, I do.
You don't want a jury trial, do you?
No, sir.
Has anybody forced or coerced you to plead no-lo?
No, sir.
I'll accept a no-lo as negotiated. I'm also going to waive your probation fees while you're on probation to help you get and stay on your feet, okay?
Thank you, sir.
And as Mr. Patterson said, it's once you complete the terms, it's going to terminate? Is that was that the agreement? It's going to go non-reporting. So the sooner you get it done, the sooner you don't have to report to probation, okay?
Yes, sir.
Exactly.
All right. Any questions?
No, sir.
All right. Good luck to you.
Thank you, Your Honor.
Good to see you.
Yes, sir. Same.
That is all I have until 1:30.
Okay. I'll see you at 1:30.
Thank you.
All right.
Yes, sir. Yes, ma'am.
Would you like for me to email you? the report? And then, can I confirm the information?
Sure.
If you don't mind.
Come on up.
Okay. I guess everyone on Zoom, I'll see you. I guess I'll see you at 1:30. Okay. All right. Thank you.
Yes, Your Honor.
Yes, I'll be there at 1:30.
I will as well.
Okay.
I will as well. Okay.
Very good. Thank you.
Our address is 71.
I'll be on Zoom, Your Honor.
Yes, sir.
Okay, Ms. Marshall
That's
Story.
all. Okay. That's all.
That's it? All right, cool. And what email address do you have?
That one. Is she supposed to be here? So I wasn't understanding, they wasn't sure whether she was going to be present or not, but we'll deal with that because I'm gonna do this one first.
Okay. It's right at 1:30. Let me go ahead and call the bench trial calendars for this afternoon. I'm going to start with the Orca A calendar. Position 1 on that case is Phaedrian Crawford. That case has been reset until the Orca C bench trial calendar on November 23rd. Position 2, Jamel Dickerson.
Having sounded for him not being present, the state would ask for a bench warrant.
I'm sorry.
Having the court having sound for Mr. Dickerson and him not being present, the state would ask for a bench warrant.
I'll give him to the end of the court calendar to get here, and your bench warrant would be granted if he doesn't appear.
Yes, Your Honor.
Orca C bench trial calendar, position 1, Quadarius Rucker.
And he is present, Your Honor, the state is ready.
Mr. Rucker, you have requested a bench trial in this matter. Are you prepared to go forward today?
Okay.
Okay, we'll be with you. Thank you, Mr. Rucker. Position 2, Kiera White.
Good afternoon, Judge. That's my case. I am ready. I spoke to her as recently as yesterday, Judge, so I expect her. Anyway, I just texted her to find out where she's at, Judge.
Is the state ready to move forward?
The state is ready to move forward, Your Honor.
Okay, we'll see if she joins us. Position 3, Robert Willis.
Mr. Willis in court. Robert Willis.
I think there's somebody outside with the last name Willis is what I heard, but let me check.
Officer Hill, Robert Willis.
Outside, Judge.
Okay.
And yeah, on that case, we're expecting the officer in just a few minutes. Can we just hold on that one to see if that officer arrives?
Okay. Good afternoon, Mr. Willis. I'm doing fine. You've requested a bench trial in this matter. Are you ready to proceed today?
Yes, sir.
All right.
Yes, sir.
Did you hear what I said?
Yes, sir.
Okay, and you're ready to proceed today?
Right.
Stand up for me. I was asking if you're ready to proceed today.
Oh, yes, sir.
Okay, have a seat. All right, Mr. Rucker, come forward, please. We'll start with
I apologize for interrupting. I have that there is also a Orca E bench trial calendar with Jessica Onmanye for today.
you'll have that calendar.
I'm sorry. Jessica, last name ANYANWU.
And I have that case number as well, and I have that calendar, but Ms. Yonwu is not our case, Judge. But
She is pro se, Your Honor.
Is this cited this on that person? Because that's my case. Is it cited for the 20th?
Yes, 9/28 at 1:30 PM.
Okay, give me a minute. Let me look at it.
And let's make sure that she received notice that she's supposed to be here today. Okay. Let's see, good afternoon, Mr. Rucker. I'm Judge Eric Morrow. You've come in before, you requested a bench trial the last time you were here. So let me explain how this is going to work today. The state has the burden of proof. That means that they have to prove your guilt beyond a reasonable doubt, okay? You will have the opportunity of, with whatever witnesses that they present, you'll have the right to cross-examine them, meaning you'll have the right to question them if you choose to, okay? Once they complete their case, you will have the opportunity to either testify on your own behalf. You have the absolute right to remain silent. Anything you say can be used against you. You do not have to testify in this regard. You do not have to put up any evidence in this regard. But if you do have evidence that you want the court to consider, then you will be given that opportunity. Okay.
Okay.
You have been charged in the state court of Fulton County, state of Georgia, versus Cordarius Shanton Rucker, accusation number 20 CR 005803F. And the accusation reads as follows: I, Keith E. Gammett, Solicitor General for the County of Fulton, state of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Cordarius Shanton Rucker with the offense of criminal trespass, a misdemeanor, for that said accused in the County of Fulton, state of Georgia, on or about March 6, 2020, did knowingly and without authority remain upon premise of Allen Hill Apartments after receiving notice to depart in violation of OCGA section 16-7-21, contrary to the laws of this state, the good order, peace, and dignity thereof. I signed Keith E. Gammett, Solicitor General. And it's my understanding that you have previously entered a not guilty plea to that charge. Is that correct?
Yes.
Are you maintaining your not guilty plea and you requesting a bench trial? Is that correct?
Yes.
You have also been given the opportunity to hire counsel in this matter. It's my understanding that you did not qualify for the services of the public defender. As such, we did give you the opportunity to hire counsel, but you're proceeding on this matter pro se. That means without the assistance of a lawyer. Is that correct?
Yes, sir.
Okay. Yes. Mr.
And Your Honor, the police, the court says I wasn't here on previous occasions. He might need to be warned about the dangers of proceeding pro se, because I think the law does require that.
Okay. Well, anytime
Unless that's been done previously.
anytime that you have the right to have the assistance of a lawyer in this matter. You know, you're not a lawyer. You may not know what the rules of evidence are. You may not know quite a few things that a lawyer that represents you might know. In this case, this charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. So I'm not saying that that is something that you would receive in this matter, as number one, I don't know the facts of the matter at the present time, but that's the maximum penalty that you could get, and that would depend on things that the court would take into consideration if you are deemed to be guilty of this. Would be your past criminal history and the violation of itself. Okay. Do you have any questions that you want to ask me regarding any of that?
No, sir.
Okay. Mr. Patterson?
Yeah, again, Your Honor.
Yes.
Your Honor, at this time, we call Officer Colley.
If you'll come to the podium, I guess, Officer Colley. And if you want to swear in, Mr. Patterson.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And if you will, you may lower your hand and state your name for the court.
Cyrus Conley,
And how long have you been for?
with the Atlanta Police Department,
And how long have you been so employed?
13 years.
And you are post certified?
I am.
And did you have the occasion to come in contact with Cordarius Rucker on March 6th of 2020?
I did.
And can you tell us what apartment complex that was in?
Allenton Apartment Complex,
And do you recall the address?
3086 Littleton Road,
In what city?
Atlanta, Georgia,
In what county?
Wilton County.
Okay. And if you will, tell us about the nature of your contact with Mr. Rucker.
So as a sergeant, I'm employed with a private entity, which is 3086 Littleton, as the coordinator for their off-duty police patrol. So we employ off-duty security and police. So I was out that day. One of my security officers stated that there was a male in the car smoking marijuana.
he had the gas fan, he was talking to me. When I went up to the vehicle, I could smell the strong aroma of marijuana. We detained the guy so we can see if we can find more marijuana. There was no marijuana inside the vehicle, but there were marijuana plugs scattered throughout the floor of the car. So at that time, we asked the individual to leave the property. He refused to leave several times, where he in fact flagged down one of my other officers that was on duty to tell him that he was being harassed by us, and he was asked to leave again several times. And then the officer effectively arrested him on trespass for refusing to leave the property after the agent of the property asked him to leave several times and he refused to leave.
And let's talk about the agent of the property. Were you present when the agent told him to leave the property?
I was.
And did you hear that conversation?
I did hear the conversation.
Okay. And as a result of him refusing to leave, he was placed under arrest for criminal trespass.
Absolutely.
Okay. Your Honor, that's all I have.
Mr. Rucker, this is your opportunity to cross-examine the witness. If you would have any questions that you would like to ask him, you will have the opportunity, if you choose to testify on your own behalf. Again, you don't have to, but if you have any questions you would like to ask of this witness, now is your opportunity to do that.
Yes.
When?
Okay. When did you search my car?
We searched your car.
When?
I can't give you the time. At the time that we noticed that we could smell aroma of marijuana, that gave us the probable cause to go inside your vehicle.
Okay, and you said that I was smoking weed inside the car. How long was I sitting in the car?
I can't tell you that because I was called to the scene after I was notified by security that you were sitting in the car smoking marijuana.
So by your officer, he told you I was sitting in the car smoking marijuana?
Absolutely.
Okay, that's all I had to say.
And just a couple, I'm sorry.
Nothing further?
It was further. I want to say something for myself.
Okay, you'll have that opportunity if you.
Okay.
Okay.
And officer, did you determine whether he lived there or not on that complex?
He was not a resident, and that was one of the things that we tried to initially find out if he was a resident, because we can't criminal trespass a resident. So we noticed he wasn't a resident. That's when we issued a criminal trespass on the individual.
Thank you so much.
Anything further of this witness?
No, Judge.
Can he be excused?
Yes.
All right, thank you.
Thank you.
Call your next witness.
State rest, Your Honor.
Okay. Now, Mr. Rucker, this is your opportunity to present your case if you want to. Let me just remind you that you have a right to remain silent. Anything you say can't be used against you. You do not have to testify in your own on your own behalf. You don't have to say a word in that regard. If you would like to testify, if you would like to present evidence, that now is your time to do so.
Yes, I only like to testify on my behalf.
All right. Understand that if you're waiving your rights, that the solicitor is going to have the opportunity to cross-examine you and ask you questions regarding your testimony. You understand that?
Yes.
Okay. And you still would like to testify?
Yes.
All right. So if you'll come to the podium for me, please. Will you raise your right hand? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Thank you. What would you like to tell the court, Mr. Rucker?
On that day where we discussed it, I was called to the apartment by my grandmother. It was around the COVID time. I was bringing food to my grandmother. Once I came in the apartment, I came inside the apartment. When I parked, I got out the car, went inside my grandma's house, gave her the food, and came back out. Once I stepped inside my car, by the time I looked down to crank my car up, when I looked up, I was boxed in by the security guard, which he then told me that he smelled the odor of marijuana coming from my car, which was like, my car is right here. He was all the way across the parking lot over there. Like, they was parked all the way over there. So I was never sitting in my car. I had got in the car to pull off, and they boxed me and telling me to get out. They smell marijuana in my car. And that's when I told him I'm not letting him search my car because he's not a police officer. He's only the security. So I was telling him he can't search my car. And the only thing that I remember is the security guard, he walked away, got in his car, in the security guard car, and pulled out. I was still standing outside talking to my grandmother. Once I gave my grandmother, she was outside when everything, the commotion was going on. I was getting in my car finally. That's when the police officer, when he came back down with the police officer in the security car with another police officer. And that's when we came, they was saying something, but when I got in the car to leave, they never did ask me to leave. Once I got in the car, like I was finna leave, he was like, no, step out of the car, we finna lock you up and take you, arrest you from the trespass. And I was like, I was finna get ready to go anyway. I was only over here to drop something else to my grandma for COVID. Like, and I was telling him, explaining to him that I don't hang in the apartment because there was a whole thing going on in the apartments with, the security guard riding up on people, and they would lock people up. But I never hung in the apartments. They never point me out and say I've been out there because I don't go out there. The only time I go out there is to take something to my grandmother. I don't hang out there. I don't be out there. So once I was telling the officer that, he was like, well, I still had to arrest me. And then once they arrested me and took me to the police station, I explained the same thing to the judge. And she was like, and she just told me to come to court and explain to the judge. Because I never was in the car smoking weed. And when I came out of my grandma's house to get in my car, and by the time I caught my car to look up, they had them block me into the parking spot where my car was back in and wouldn't let me out. So that's when I told him he couldn't search my car because he's not a police officer, he's a security guard. So he left and came back with the police. And then he did not ask me to leave. And then he was like, I know the officer that was out there, I don't remember if it was that officer, but I know it was an officer out there that came in the patrol car. And he was like, you're gonna have to leave. And once I was getting in the car, and I was handing my grandma the rest of the stuff, once I was getting in the car, that's when he asked me to step out the car and was like, I'm gonna take you to jail for criminal trespass, because he asked you to leave already. After I handed my grandma the stuff.
Anything further?
That's it.
Mr. Patterson?
And Mr. Rucker, at the time of this incident, what was your physical address?
What
was your address?
My address?
At the time of this incident.
At the time of that incident, I was staying with my grandma at that time of the incident.
But you were not a resident.
I was not a resident.
And you were asked to leave at some point.
No, he didn't ask me to leave. I was already getting in my car to leave. And then once I got in the car and I was getting out the car and I handed my grandma the rest of the stuff, that's when he said, oh, no, he asked you to leave. I'm arrested for criminal trespassing. But I was already in my car from the leave.
But you heard the officer testify that he had asked you to leave.
He did not ask me to leave.
Let me finish the question. But you did hear the officer say that he had asked you to leave in presence of another security officer and you did not leave. Do you recall that testimony that the officer just said?
The testimony he made right here? Yes, I heard it in the testimony.
No further questions, Judge.
Anything further?
No, sir.
So at one point you lived, where did you go in to live?
2973 Military Road. She stays out there now.
And how long did she live there?
My grandma been staying out there for 30 years.
And how long were you living with her?
My whole life. Until when I moved out, then when I lost my place, I was staying with my grandma and my things over there. But I went out there, I worked 2 jobs, so I'm never out there. I work for the city of Atlanta, and then my night job, I work for TA Petro. So I'm always at work.
Anything further, Mr. Rucker?
No, that's it.
Just argument, Your Honor.
Okay. You can step back over.
Your Honor, it is clear that Officer Cawley was responsible for a team of people that was actually working security for the complex. The court would be concerned about whether it would be hearsay that whether Officer Cawley, he heard in the presence of another security officer asking him to leave. Under the authority of Daugherty v. State, anything that's said in the presence of the defendant is not hearsay, it's actually evidence. So that testimony from Officer Cawley would be competent evidence that he was asked to leave and refused to leave. Secondly, even if the court assumes that to be hearsay, then under the authority of Mormon v. State, which is Georgia Supreme Court, that statement is also admissible to prove the officer's conduct as to why he actually arrested the defendant. So there are 2 grounds. And last but not least, the law puts the burden, although we're asserting none of this is hearsay, the law puts the burden on the defendant to object to anything that he thinks may be hearsay. And if he does not, under Georgia law, it is completely waived. In previous law, in the last 10 years or so before that, hearsay was automatically inadmissible and had no probative value whatsoever. But Georgia changed that law, and now you have to object to hearsay, otherwise it's considered competent evidence. So the state has put forth competent evidence that he was asked to leave, refused to leave, and then he was arrested for criminal trespass. We asked the court to find him guilty.
Mr. Rucker, anything further that you would like in closing? To say to me?
Like, if I am found, I just want y'all to consider my 2 jobs that I'm working. Like, and I don't hang out there, and I don't have a problem. I don't go out there. So, you know what I mean? Around the whole time all this was going down, it was like a whole lot of folks. So just for the environment in that apartment complex. So, and I just feel like I was targeted because of the car that I was in, but I was never in the car smoking weed. Never. And he was waiting across the parking lot when he said he smelled marijuana coming from my car. And I was never in the car smoking weed. And I don't even remember them searching the car. Because I told him to search my car. That's why he went and got the police officer and came back to the police officer.
The court is concerned about the underlying issue, even though there was testimony that there was marijuana being smoked. Although there was testimony of the smell of marijuana, that there's no charge of marijuana that the court has before it that was brought by Mr. Rucker. I just believe that this was a misunderstanding. I have to assess the credibility of the testimony, and I do find Mr. Rucker's testimony to be credible. I believe that this was a misunderstanding that did not rise to the level of a criminal trespass, and so I'm going to find you not guilty, sir.
Thank you.
All right. Good luck to you.
And can I say one thing else? In this situation,
Hold on. I'm not going to be able to probably answer your question. And again, I don't want you to get yourself into.
Oh no, it had nothing to do with me. It was with the apartments that my grandma stayed out there, and they was like, and she was telling me before I came to court, like what they were waiting for to see what happened in the court. And I was saying, can I like get the paperwork to take to her so she won't get put out?
Oh,
okay. They were trying to put her out because of this.
Yeah, we'll give you something that lets you know that I found you not guilty. Okay. All right, so if you just want to hold on for me, we'll get you that paperwork for your grandmother.
Thank you.
You're welcome. Did your client come in, Mr. Haddad?
Yes, Judge. She's
Okay.
here and we're ready.
Are we ready to proceed on position number 2, Kiara White case?
Your Honor, can you give me 2 minutes? Let me speak to the victim.
Okay, is there another case that, yeah, go ahead.
Anyone related to
today's hearing.
Okay, thank you.
Waiting, I just wanted to make sure that Zoom is still operational for the court reporter.
Ms. Greenhouse, can you hear me?
Thank you. I can hear you. The only pictures that I see, however, are you, Judge Morrow, and myself. I'm not seeing the where the prosecutor sits or the podium anymore. I am still hearing everything though. So I actually could go with this as it is. It just would need any new speakers to identify themselves for the first time they speak.
Okay. And I think they may be trying to bring it back up, Ms. Greenhouse. Thank you.
Okay, thank you.
One copy of the accusation on Ms.
Oh,
White.
okay. So that's the afternoon calendar.
Right.
Is
And
that-
that was the issue with the using. I'm not playing.
Not a problem.
Just saying. So not someone who's
Okay, okay,
Oh, one or two.
Just want to be fine.
okay, okay. Thank you.
Yes. Yeah, it appears we're ready on Miss Kira White whenever you are.
Okay, all right.
Ms. White, what? Judge, I'd like to invoke the rule,
Okay.
sequestration.
If there's anyone in court who is going to testify in this matter, I'll need for you to step outside of the court.
That includes both of the state witnesses.
Anybody here that I'm going to be called to testify, you didn't step out in the hall, I called your name.
Mr. Haddad, I don't know, that door is open, so I don't know what can be heard out there. You're better to tell me. Can you hear me in here when you're out there?
Yes, Your Honor.
Yeah, why don't we close the door? Thank you.
Thank you, Judge. I can do it.
Okay, the case of State of Georgia versus Kiera White is called. Are we ready to proceed?
Yes, Judge.
All right. Good afternoon, Ms. White. I'm Judge Eric Morrow. This is the a bench trial that you have in your counsel has requested regarding accusation number 20 CR 005804F. The accusation against you, Ms. White, states, I, Keith E. Gammett, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, to hereby charge and accuse Kiera White with the offense of theft of service, misdemeanor. A misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about February 22nd, 2020, did by deception and with intent to avoid payment knowingly obtain services to wit a party on a party bus from Pure Party Bus, which is available only for compensation in violation of OCGA section 16-8-5, contrary to the laws of the state of this state, the good order, peace, and dignity thereof, signed Keith E. Gammett, Solicitor General. Previously, Mr. Haddad, a not guilty plea was entered by Ms. White, and she's requested a bench trial. Is that correct?
That is correct, Judge.
Okay, thank you. Are you ready to proceed?
Yes.
Call your first witness.
Are we gonna do a brief opening, Judge? or
Oh, if
Or wish to go straight into testimony?
it's up, would you all like to open? If you wanna open, I'm happy to hear it.
I'll keep it brief, Judge, but no, I'm just gonna give you flavor to the court.
So-
Your Honor, the case is pretty simple. The defendant in this case engaged a bus company to do a private party type bus, paid the deposit, went to the location, and since they were unhappy with the driver, they simply took Uber and left the location and never paid the remainder.
Okay.
Your Honor, it is a straightforward case. Briefly, on behalf of my client, Ms. White had contacted this party bus to transport her and her friends to a club. A deposit was paid by my client. The contract was never actually signed, but my client did pay the deposit. The bus was late at least an hour and a half to the event, to their location. Of itself, there's an astronomical fee where they reserve the club, and it's not just my client, but I think there's going to be testimony about 10 grand to reserve the club. So when the driver showed up, it's an hour and 10 minutes late. The bus was dirty. The Bluetooth was not working. And during the transportation, during the drive, but something during the drive, the bus driver made inappropriate comments towards my client and other women in the bus. They got to the club, they got out, they went in. Feeling uncomfortable with the driver's behavior. When they came out, there's going to be testimony that the bus was not there, Judge. They actually decided to take Uber. They went home. That's basically the case. And the only, well, I'll say it for closing, Judge, but that's essentially, I think the state and I are going to agree on some of the facts, of course, like any case, but that's the case.
Okay, thank you, Mr. Dodge. Mr. Patterson?
Yeah, at this time I call Brandon Kennedy. We'll go over to the court.
Mr. Patterson, because we have this issue with the court reporter, if you wouldn't mind having him spell his name when you.
So will you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may lower your hand, and you got to speak loud because there's a court reporter taking everything down. Tell the court your name.
Brandon McKinney.
And how do you spell that?
Brandon, BRANDON, McKinney, McKinney.
And do you own a party bus company?
Yes, sir.
What is the name of it?
Pure Party Bus.
Where is it located?
Mableton, Georgia.
Sorry,
Mableton, Georgia.
Madison, Georgia.
Mableton. MABLETON.
Is it okay if you take your mask?
Oh, of course.
Okay. And can you repeat that?
Mableton, Georgia. Yes, sir.
Okay. And did you have an occasion to have any contact in terms of leasing your party bus out to a Kia or white?
Yes, sir.
Tell the court the nature of that.
Take my phone. It's that date.
Would it be on February 22nd, 2020, or it's a different date when she first contacted?
The first, she booked the bus on February 19th of 2020 under the ID care, well, under the name of White Mills Scooter ID. Our process is we send your contract via email. You apply to the email with your contract and your itinerary and your ID. It was a problem to send the paperwork via email as we requested, but we were doing business, so like, we just bring it with you. It's fine. Bring the paperwork, the ID, bring the money. Well, she brought the paperwork.
And she said she brought the paperwork. Where did she bring it to?
To the pickup location.
Which is where?
5525 State Way, Atlanta, Georgia.
And would that be in Fulton County?
Yes, sir. I would imagine. Yes, sir. It's Atlanta, Georgia.
So who is your business located? What's located at that location?
That is a residence, I believe, in Airbnb.
Okay. And tell us what happened next when she arrived. Did she come with anyone?
There were about 6 to 8 people, I guess. I wasn't there, but the reservation was supposed to be for 6 people. Well,
No, I would just object as far as hearsay. I just want to be clear. I'm not sure where this is going, but I think the testimony is he was not present. I'll ask Mr. Patterson to.
Don't testify to what somebody else said. You testify to what you personally know.
Okay, the reservation was for 6 people. So I guess 6 people were there.
And when she arrived at the location, you were not there.
I was not there.
Who was there?
Elderman Allen.
Okay. And let's move forward then. Did you ever receive the payment in some final way in terms of that deposit?
No, we received the deposit via debit card.
Okay.
I think.
And how much was that deposit?
Let me make sure. I have a receipt for a deposit for $124.20.
And what was the total amount that you charged?
The total amount was
$585. And she paid the deposit, and then your company performed services by taking her to a location.
That's correct.
And what's the name of the driver?
What's
Took her to the location.
Elton Allen?
And he is here today.
Yes, sir.
And did you later learn that the final payment was not made?
Yes, sir.
And how did you discover that?
So, our policy, we get paid on arrival. It's stated in the contract. So when we get there, pay. Well, the money wasn't on the scene, or we pay when we get to the next, from what I was told, we'll pay when we get to the next location.
So the bottom line, she was supposed to pay before she got on the party.
Exactly. Yes, sir.
Paid in full.
That's exactly right.
That did not occur.
Did not.
And Young, I think that's all the questions I have. I'll call the next witness after he cross-examines.
Thank you, Judge. Mr. McKinney, good afternoon. I'm going to try and speak loudly. The court reporter is here with us, but so if you don't understand any of my questions, feel free to ask me to rephrase. So I just want to be clear, Mr. Allen was the actual driver.
That's correct.
All right. And your testimony is that you had, you didn't know Ms. White from before, did you?
No.
She's a stranger to you?
Completely.
Okay. All right. And do you recall in this case that she reach out to you by email or by phone? Y'all talk on the phone at some point?
I'm pretty sure we had to because I took the reservation.
Okay. All right. So you took her reservation, I think you testified sometime around February 19th of 2020. Is that correct?
That's correct.
You did receive a deposit of $120, correct?
That's correct.
And your testimony is that it's your policy, the policy of the company is that when the bus arrives to pick up the customer, that customer is supposed to pay the driver at that point. Is that correct?
Sure.
All right. All right. Now, and in this particular case, did you started testifying about a contract? Did you email her the contract? Is that correct?
That's correct.
And if I understood you correctly, you did not receive the contract back by email.
That's correct.
All right. So you kind of, so there was never really a signed contract. Am I correct?
No, it was a signed contract.
She signed it?
Yes. Well, it was presented to him.
Right.
A signed contract.
She signed the contract.
I can't say who signed what. All I know is that's what was provided.
All right. So when you say provided, you provided just the regular contract that you normally use, correct?
That's correct.
All right. And it's, do you recall, and you may not, the driver may, but was the bus, what was the contract for? I guess, let me rephrase. Was the bus supposed to take Ms. White from, point A to point B?
It was from point A to point B, back to point A, as represented.
So, and your understanding is that the driver appeared at point A, correct?
Yeah, I made it to point A. That's correct.
Now, and you may not know this, but in the contract, was there an agreement as to what time the bus was supposed to show up, the time?
No, it's not. The contract does not have times in the contract.
Okay.
You can submit your itinerary.
Okay. So was an itinerary submitted to you in terms of what time and what day the bus was supposed to be in?
That's correct.
All right. And and obviously you cannot testify to the condition. How many buses did you own at the time?
I can't remember at the time. Maybe 2.
Now, did you understand that you're still?
Wait a minute. Hold on. I'll tell you. 2010. No, 1.
Now, it is your testimony that you're still owed the money. Is that correct?
Yes, it's absolutely correct.
Did you attempt to sue my client?
Yeah, I would object. That would be totally irrelevant.
Actually, Judge, I think it's extremely relevant. I mean, it goes to whether he did that or whether there's a judgment. I don't know. So I think I'm entitled to ask that question.
Proceed, Mr. Clark. Overruled.
Mr. McKinney, I'm sorry. Did you sue my client for the outstanding money?
Is this part of the suing process?
Let me rephrase. Is this the only court initiation that you're aware of?
That's correct.
That's all the questions I have.
And just a few more questions. What club, what location was she taken to?
1008 Brady Avenue, Atlanta, Georgia.
And that is in Fulton County.
That's correct.
And she was supposed to pay the remaining money when she left the club. Is that correct?
She negotiated with the driver.
But initially it's supposed to be paid at the pickup spot.
At the pickup, yes, sir.
Somehow or another, through some conversation, she indicated she'll pay it when she leaves the club.
That's correct.
And that never occurred.
That never occurred.
Okay, no further questions.
Nothing further, Judge.
Thank you, sir.
Yeah, at this time, I call Mr. Allen, F-E-L-D-E-V-E-L-L, Allen.
Is Mr. McKinney excused?
And feel free to go right to the podium over there.
The court was asking you whether he's excused.
No, I didn't know if it.
Yes, I excuse him. That is
Okay, all right, so if he's not going to testify anymore, he's welcome to stay.
Sir, will you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may lower your hand. Spell your name, please.
E-L-D-E-V-E-L-L.
And did you have the occasion to come in contact with Kiara White on February the 22nd of 2020?
Yes, I did.
And tell the court the nature of your contact and conversation.
Well, I'm the driver. I arrived at the house to pick up the party. Once I arrived, she came out to be out shortly. I waited about 20 or 30 minutes. They all came out. The party came out. I don't know, maybe about 8 or 9, 10 of them. They came out. They sat on the bus. We sat for about another 20 minutes. During that time, 2 other gentlemen boarded the bus, and they didn't stay long. They were just laughing and talking. They unloaded the bus. The 2 gentlemen. They got off the bus. She came up. One of the young ladies came up and said, "We're ready to go." I started the bus. The 2 gentlemen that got off the bus, they got into a vehicle and followed me to our destination.
Let me back up.
Yes.
Was there any money given to you when you picked her up?
No, sir.
Who was responsible for getting the money?
Me. I was responsible for
Did you
getting.
get any deposit?
No, I did not.
Okay, but you were aware that a deposit was paid before?
Yeah. Yes, sir.
Was there any conversation with you and anyone on that bus about getting the remaining of the money?
One of the young ladies told me they need to stop by an ATM.
Okay. And when are you required to get the balance?
I'm actually required to get the balance at pickup.
And but that did not occur.
No, sir.
Did you allow them then to go ahead to the club and you were supposed to get it later?
Well, not to the club. My intention was to, on the way route to the club, is to stop by the ATM.
And did you do that?
No, I did not. I didn't have a chance to.
And why not?
Because once we got close to in the proximity of our location, when I was at the light, the traffic light, I heard the door in the back of the bus. I'm in the partition, so I can't see unless there's a little window. But the window had tinted windows on it, so I heard the door open up and I was at the light, which seemed kind of odd to me for us to be in the middle of the traffic. The door opened up. Well, I took the bus in park, I opened the window, looked back, the bus was empty.
Everybody, including Ms. White, was done.
They cleared the bus.
Now, is that when you were on the way to the club or when they were?
I was going to the ATM.
Okay. So did you ever make it to the club with any of them?
No, I never made it to the club with any of them.
Okay. So before you.
If I made it to the club, I didn't see a club anymore. I was at a stoplight in a traffic. That's when you offloaded. Now, if the club was across the street or somewhere, I was not aware of that.
In other words, they got out before you felt you were at your final destination.
Exactly. And the tenants were they were going to they moved the bounds before they got to the club. They know that that's in the contract. They are aware of that.
So they simply opened up the door and vanished.
And then I tried to call, the calls went unreturned, I text, nothing, even into the next day, nothing.
And the defense attorney is probably going to ask you about the condition of the bus. Was the bus clean?
Always.
Any trash or anything on the bus?
No, sir.
And was there any conversation of an improper nature between you, maybe some sexual conversation or any type of conversation that was inappropriate with anybody on the bus and you?
No, sir.
Okay.
No.
But the bottom line is that they vanished before you knew you had got to the club.
Right. Before I knew I got to the club, before my knowledge I got to the club, I was at the traffic light, four-way stop. I heard the door open and they took off running.
No further.
Thank you, Judge. Mr. Allen, prior to you picking up that group, you didn't know who Ms. White was, correct?
Correct.
And so you really didn't negotiate the contract. That's not your role, is that correct?
No, that's it.
And your role in this particular job is really to
get from point A to point B.
And you were informed perhaps by Mr. McKinney that you're supposed to go to point A, is that right?
Correct.
And did you appear, you may not remember the address, but did you appear to at point A, is that correct?
Yes, it was Atlanta, Stableways, 1003 Stableways.
Now, normally, when you're retained or your services or the company's services retained, there's a particular time you're supposed to show up. Is that right?
Correct.
And is that your testimony that you appeared on that day on the exact time?
Not the exact.
Say exact. I'm not talking about 2 minutes late here and there. I'm talking at.
I always arrive my destination before time due to Atlanta traffic.
So it is your testimony that you did arrive there on time. Is that right?
Yes.
I just want to make sure.
Yes, before time, but yes, I was there.
All right. And at some point, they being perhaps Ms. White and some other folks got on the bus, correct?
Correct.
And normally, if I understood you correctly, you're supposed to collect the money right then and there. Is that right?
I'm supposed to collect the money right then and there, yes, sir.
And that didn't happen right then and there.
No, it didn't happen.
And essentially, what was negotiated or whatnot was that they're going to pay you on the way there.
Correct.
So the plan was that you're going to drive to an ATM machine before they get to point B.
Correct. That was our intention.
And but you actually never made it to an ATM.
No.
So it's your testimony when you were at a stoplight or a stop sign when you heard the door open. Is that right?
Yes, I heard the door open. The music was really loud. I was close enough to the door where I could hear. You can hear steps. She was going down steps. You can kind of hear that.
So describe the vehicle for me. Is this literally a bus?
It's a bus, and it has window partition. Like I said, there's no window right on the side, but windows closed. It's tinted, so I don't really see what's going on around the bus.
And is the bus like is it a school bus, or is it just a?
It's more like a shuttle passenger bus.
All right. So, and there's no front passenger with you.
No, it's not designed to have a passenger seat.
And it's your testimony that when you got. Well, let me ask you this: when you were at that light, when you heard the noise. How close were you to the club? I mean, you knew where you're going. Right?
I knew I was going, but I didn't really have any knowledge to be exact. My GPS was looking for whatever. Thank you, because I didn't put the club. I knew it was like a step.
So your thinking was that the ATM is close to that position.
Correct.
All right. So your testimony is that they got out. And you notice that they're gone.
Right.
Did you go to that club?
No.
Did you wait for them at the club or anything else?
I started making contact with them over and over and over for hours. They never responded, so I'm ready.
All right, now the numbers you said you tried to call, who you trying to reach?
There was lady, Sarah. She was supposed to be the host.
And now what's the initial understanding of the agreements that you're gonna get them from point A to point B and then from point B back to point A?
Correct.
Obviously, that never happened from B back to A.
No, right.
And I think your testimony is that you never, during that drive or before or after, you didn't make any inappropriate comments or like that towards the end of the passage.
Oh, no, sir, I'm here professional. I'm at work. So,
All right, that's all the questions I have.
And I just have a couple. That Sable address, that's in Fulton County.
yes, sir.
And when they jumped out the bus, is that in Fulton County?
No, where they jumped out the beach was actually in Atlanta, close to the downtown area.
Do you know what county Atlanta sits in?
Fulton.
So then it was in Fulton, what was that?
It was origin.
Thank you.
Nothing for you, Judge.
Thank you, sir. We appreciate it.
Okay.
Can Mr. Allen be dismissed?
Yes, Judge.
All right, so you're free to stay, Mr. Allen, but you're not required to.
State rest, Chairman.
Say it again?
State rest.
Okay, Mr. Don?
The defense would like to call Ashley Smith. I can get better, Judge. Ma'am, just stand right by the podium. Ms. Smith, are you comfortable enough to remove your mask? You can leave it on if you wish. It's up to you.
Oh, it's fine.
All right. Before we start, ma'am, we'll have a court reporter that's listening in. So just make sure to speak loudly enough.
Okay.
Let me ask you to raise your right hand. You swear you can put your first behind you so like someone in fear. Let me ask you to raise your right hand. You swear affirm testimony about the business line is the truth, the whole truth, and nothing but truth. So help you God.
Yes, sir.
You can lower your hand. All right. Can you state your name for the record?
Ashley Smith,
The spelling of your first name.
ASHLEY,
Ms. Smith, how old are you, ma'am?
25.
And do you know Kiara Wines?
Yes.
Is that the young lady that's to your right, sitting down?
Yes.
And how do you describe? Are you all friends? Grew up together? Just briefly.
Friends.
Now, I'm going to take you back to the events of what happened back in February of 2020. I'm going to just briefly correct you. I'm talking about the time perhaps you all went to a club or had plans to go to a club.
Mm-hmm.
All right. And is that a yes?
Yes. Sorry.
All right. Now, were you in charge of making any reservations with the bus or anything of that sort?
No.
What was the plan that evening? Were you all what were you all heading out to?
We were heading out to a club called Compound.
Okay.
The plan was for the driver to come pick us up and then, drop us in there or whatever.
All right. Now, the driver, was this somebody you knew, or were you all hiring a limo service, a bus service, a party bus?
We were hiring a party bus.
And as far as you know, it was your friend, Ms. White, who was in charge of making that reservation?
Yeah.
Okay. All right. So describe to me, you were at the home or wherever you all were. Was the bus supposed to be there at a particular time?
Yes.
Okay. Do you recall whether the bus was there on time?
I recall us coming out of there and the bus wasn't there, so it wasn't there on time.
Right. And do you recall how long did the bus show up at some
point? Yeah.
Was it how long after you first came out that you noticed the bus?
Maybe about 30, 45 minutes.
All right. When the bus got there, did you all end up getting inside the bus?
Mm-hmm.
And
yes.
Pictures
yes. Sorry. Yes.
And how many of you got inside the bus?
Like 4 of us. I'm
Do you recall anybody that was there?
Yeah.
Who was just mentioned, like a name, first and last name?
Deshaun and Janaya. That's how you remember, and Lakiba.
Okay, and Ms. White?
Yeah, of course.
The court reporter's having a difficult time with those names, so if you can get her, if she knows how to spell them or if she can pronounce them, for Madam Court Reporter.
Deshaun is spelled Jeshun, and Janaya is spelled Jania.
Thank you. So y'all gone on the bus. Did you pay, by the way, did you pay any deposits or anything like that in the bus? Okay, all right. Just
No.
make sure, remember to say yes or no. All right. So y'all got on the bus. Tell me, how long was the drive from where you got picked up to wherever your destination was, the club? Just roughly, you recall?
20 minutes.
All right, and during that time, could you describe the condition of the bus? How was it?
The first thing we noticed when we got on the bus was the area where we put our drinks at, like our alcohol drinks and everything, had roaches and bugs in it. So like that was already a red flag because we were like, we're not even drinking anything, we're not using the cups aren't clean or anything. The bus was not the same as the pictures that we seen. So it's like false advertisement at that. So we already paid the deposit, so it's like you might as well just try to get out there.
All right, did anything happen between the driver and y'all? Any statement, comments made by him or anything like that?
I don't remember the specific comments, but I remember him making us uncomfortable with 30 like little things he was saying to us and everything.
Now, did y'all get to the club?
Yes.
And how close were you dropped off? Were you dropped off right in front of the club or?
Like across the street, yeah.
And when you say cross the street, I just want to be clear, when you got out of the bus, could you see the club?
Yes.
And how much of a walk would you have to from the bus to the club?
So the club is about a 5-minute walk.
5-minute walk?
Yeah, because how downtown Atlanta is set up, it's like a parking lot that's down the street from the club. So it's like 4 or 5 minutes.
Okay. Did y'all run out of the bus to your location?
No, we had heels on. No.
All right. And you said heels?
Yeah, we wore it. We weren't running or anything.
You were dressed up, is that?
Yeah. Yeah.
So were any words did you say anything to the driver as you exited the bus or just walked?
No, everyone just was like, okay, bye. And that was it.
And now your understanding was the bus supposed to stay or come back and pick you up and return you back to your original location?
Yes.
And y'all went to this other club, is that correct?
Yes.
How long roughly were you there?
30 minutes, because the club was getting ready to close, probably an hour, 30 minutes. Yeah, it's getting ready.
Not there too long.
No, because we got really.
And when you left the club, was the bus there?
No.
And did y'all end up going home, and how did you get out?
We ended up going home. We ended up picking up our boyfriend's car and ended up going there.
That's all the questions I have.
How you doing? How you
Yeah,
doing? You are aware that that was an agreement that you all would stop at the ATM machine to get some money before you got to the club.
No.
So you don't know anything about that conversation?
No.
Did you know that that was a balance that was due that night?
Yes, if we drove backwards.
Sorry.
If we rode backwards there on the bus, yes.
You said if you rode back with them?
Yes.
So you're telling the court that you had an agreement in advance that you'll pay a deposit, but you don't pay the rest unless you get back on the bus.
It was never a document signed, so it wasn't really like agreement.
Let me ask you, I'm asking you your personal knowledge.
Yeah.
Are you telling the court that you are aware that you were supposed to pay a deposit before you got on the bus and that you don't ever pay the balance unless you ride back on the bus? Is that what you're telling me?
Yes.
Okay.
Yes.
Let me ask you this. I'm gonna stand by that statement. You're telling us one more time that you believe you didn't have to pay any money unless you got back on the bus and left.
Yes, until the ride is complete, yes.
Okay, so who was supposed to pay this month to your knowledge?
Monitoring care.
Who's sitting right here?
Okay.
Then why did you all get off the bus? Just open the door and get out without letting the driver, or without him knowing that you all were getting out?
Because we didn't let him, he opened the door for us and we left and said, bye.
Did y'all have a conversation with him as to when he's supposed to come back?
No.
So how, if that's the case, how does he know when he's supposed to come back?
But prior to it, yes, he knew when to come back because of the time frame that we had to even cap this. So he knew that.
But you're telling the court that at no time was the balance supposed to be paid before y'all got on the bus to go to point A?
Correct.
No further questions, y'all.
Nothing further.
Okay. Thank you, Ms. Smith. Can she be dismissed?
Yes, she's dismissed.
No objection.
Ms. Smith, you can have a seat. You remain in the courtroom if you wish. I'd like to call Kiara White to the stand, Judge.
All right, let me question Ms. White for just a moment, Mr. Dodd, if you don't mind. Can you raise your right hand, ma'am? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
But you can put your hand down. You understand that you have a right to remain silent and that you do not have to testify in this matter. Is that correct?
Yes.
You understand that if you do testify, you'll be subject to cross-examination by the solicitor. You understand that?
Yes.
Did you have a discussion with your counsel regarding you testifying today? You do wish to testify?
Yes.
So you plan on waiving your right to remain silent and testify on your own behalf, is that right?
Yes.
Proceed, Mr. Haddad.
Thank you, Judge. Ms. White, can you tell us your name and give us the spelling, at least for the first name?
Kiara White, Kiara.
All right. Ms. White, how old are you, ma'am?
25.
All right. And are you working right now?
Yes.
All right. Now, Ms. White, I'm going to take you back to February of 2020, which is why we're here. Okay. Did you hire or make contact with a company to provide you with transportation?
Yes.
All right. Just tell me, just briefly, what you did to procure that, to get that going.
I really reside in Augusta, but we wanted to party in Atlanta. It's more to do in Atlanta. So I researched like a party bus and an Airbnb. Like we was gonna spend the weekend at the Airbnb and get the party bus, take us to the club and back home. So I researched them, and that was the first ones really to come up on Instagram. And I reached
I
out.
heard you correctly. You lived or are still living in Augusta?
Yes.
Okay. So the communications. So you found this company. Did you call them, or did you send an email? Tell me how that went down.
It's about 2 years ago. Either I see them a DM on Instagram or I call. I'm really not sure.
Okay. Do you recall paying a deposit?
Yes, I do.
And I think the figure was about $124. Is that about right?
Yes.
Okay. All right. And you were the one responsible or in negotiations with the bus company. Is that correct?
Yes.
Now, you gave them the itinerary as to where you're supposed to be going?
Yes.
All right. So what was when you hired the transportation company, what was the plan to take you from point A to B and then back to point A?
Yes, that was the plan.
All right. Now, that particular evening, did the bus show up on time?
No, not on time. I had
That's okay. I don't need you. Do you recall what from best your memory? I mean, did he show up on time? The driver, did he be on time?
No, I called twice. I didn't get an answer. And then at the time, I called again. And the owner answered the phone, not the driver, and said, oh, he ran to the store. So we waited on him to come back from the store and we got on the bus. Then,
so how late do you think he was driving?
I'll say about 10, 15 minutes.
Now, was the club you're going to, was this a private club that you all like reserved or?
No, he's reserved a section in the club. It was artist performing.
Okay. So was there a time, what was the plan initially to get there, say by 10 p.m., like a particular time to get?
Yeah, we were supposed to get there at a particular time.
And you didn't get there on time, is that right?
No, because when we got on the bus, like like the driver didn't know how to work the Bluetooth. So we were playing with the Bluetooth for at least an hour. He kept calling. The owner asked him about buttons and stuff like that. And ordering, like my friend said, so party was supposed to be partying on the way there. We can't listen to no music. We can't move because it'll be not what we booked. We couldn't get the cups together to drink out of the cups and do nothing we were supposed to do. So that took like over an hour. The place is like 30 minutes away itself. And like the club had a certain time to close. Like you said, we paid $10,000 for the section. So it was like, get there, see the performance, and enjoy our money.
All right. So how many of you, your friends, got on the bus?
It was me, Ashley, Deshaun, and Janai.
The names that she mentioned?
Yes.
All right. And the bus finally left, is that correct? Heading to your destination?
Yes.
All right. Let me back up. Now, were you supposed to pay the driver at that point when you got?
No, I don't know where they're getting that from. I don't even know about me supposed to be giving them a contract when they arrive, because when the contract, send the contract to my email, but I think he wanted me to like fax it over or something, but I told him I didn't have a fax machine. Like, could I come in? And he was like, don't worry about it. So
you actually never signed officially a contract?
No, I didn't. And I didn't sign the part where I just went and looked at it like the other day when we were on the phone, and it was like something I had to sign for my card. And I didn't sign for my card. I gave my card to him over the phone. Gave him my card information over the phone so he could take my deposit. So as far as me paying him and giving him a contract when we got there, that's incorrect. When they were supposed to get the money was when we were supposed to make it back to point A. They were supposed to take it off of my card, like they did the first time. They took the deposit from the card, they took the remaining balance from the card, no cash spoken about.
So your understanding was after the club, when you went back to your original point.
Once the ride was done.
All right, now, when you got the club, did you actually make it right to the club? I think there's been testimonies to where, at what point.
So the club was kind of full. Like I said, the artist was performing, so the artist had all his cars and entourage in the front. So it's a little down the street. As far as the bus, I don't know if you ever rode on a bus like that, but from the inside, there's no way you can open it. Like, you can't just open it and run out. The driver has to get out and open it for you, so you get out. But like my friend said, we were in heels. I don't even wear heels. Like, I wasn't wearing that.
Did the driver open the door for you guys?
Yes, open the door for us. And we stepped off. Yes.
And the plan was for you all, after the club, when you're done with the party and whatnot, the concert, is for y'all to get back on.
To get back on, he dropped us back off at the Airbnb.
And when you left the club, was the driver there?
No, we ended up leaving because he was texting us, basically saying like, it's time for y'all to leave. It's time for y'all to go back. But we had already got there late, and my friend was telling me that they were uncomfortable of some comments made. I guess he told them they looked nice and stuff like that, of that nature. So we were just uncomfortable at the same fact we didn't ride back. We just got in a separate vehicle and just went home from there.
When you got out of the club, physically got out of the club, the driver was not there.
Yes.
That's all the questions I have. Status, when you have some questions for me.
How you doing, Ms. White?
Great.
You certainly are the person that was responsible for the total fee.
Yes.
And you indicated that when you got to the club, you just told the court that the bus company, the driver, started texting you saying it was time to go. You did get those texts, did you?
Yes.
So it ain't like he just left. He tried to reach you. Am I correct?
Yes.
And you never responded to him?
No.
So did you expect him to stay there till 5 in the morning since you never responded to him?
We didn't stay there for 5 minutes.
I'm asking you, did you expect him to wait forever since you never responded back?
He didn't have to wait at all.
I'm sorry.
He didn't have to wait at all.
So if he's going to take you back to your location, why wouldn't a person reasonably wait or try to reach you to say, hey, how much longer or it's time to go. He did try to do that, didn't he? But you ignored his text, didn't you?
Yes,
On purpose, because you decided you ain't gonna go back on that bus.
I'm not.
Am I correct?
Yes,
Okay, so you said also that he was supposed to take the balance off of the card.
yes,
From that day to now, have you ever reached out and said, here's my card, let me pay that back?
no,
You had no intentions on paying it, did you?
I did,
So why didn't you pay it when he first got to the location?
because that's not what we discussed over the phone.
Okay, then let me ask you this. Even though you never signed a contract, you clearly agreed verbally to what y'all were supposed to do in terms of him picking you up and bringing you back.
Yes,
So you agree that was an oral contract? You know what oral, in other words, conversation, I agree to this and you agree to that.
yes,
Okay, so you did have that type of situation, although it wasn't written down.
yes,
Okay, so there's no dispute then. You're not trying to say you never had a contract because you had an oral contract. So there are different kinds of contract, a written one and an oral. You had an oral contract.
no, I'm not saying we had an oral contract.
So you just had a conversation. It didn't really mean much.
We had a conversation over the phone.
Okay, so once again, you did see his text when he said it's time to go.
Yes,
And you decided, and your friends decided, we're not gonna pay the balance, we just gonna leave in some other way.
that's not what we said. We said we were uncomfortable. It was an unprofessional ride. We didn't get picked up on time. And we were about to leave because we had just got there and he wanted us to leave and go back. It was, like I said, unprofessional, uncomfortable. We weren't riding back.
So if you're sitting at IHOP and you get a meal and you just don't like the way it tastes, then you're just free to get up and leave and not pay for it?
That's not the same.
Use it as an example.
That's not the same. That's not the same situation. A deposit was paid.
No further questions, Your Honor.
Nothing further, Judge.
Thank
Thank
you, Ms. White. Oh, your next witness. Okay,
Just argument, Your Honor, and I'll reserve for last.
go ahead, Mr. Dunn.
Good afternoon, Judge. I'm not going to rehash the testimony. It was brief, straight to the point, Judge. I would just point out a couple of things. I mean, a few things, Judge. The contention is, I think everybody agrees that my client retains the bus to provide transportation. That was provided partially, because the testimony on the defense side, Judge, is that the bus was late. And not only was the bus late, but also to get to the club was even later because of apparently some YouTube technical issues. By the time we got to the club, Judge, they were there, I think, about 30 minutes, and it sounded like the testimony was that the driver was ready to leave. And I mean, the contention, frankly, is that they didn't meet their side of the contract, whether it was written or oral. But that's neither here nor there, Judge, because what the court has to concentrate on, obviously, this is a criminal court. The burden is on the state beyond reasonable doubt. And as I look at the statute itself, Judge, is the issue is that a person commits the offense of theft of services by deception and with the intent to avoid payments. And I think that's a high bar. And it's not a question of going to IHOP, as Mr. Patterson suggested, eating a meal, a bad meal, eating, not paying. That's not at all what happened. A deposit was paid. They were provided transportation, and there was a break. My client contends that the other side didn't meet their side of the contract. The owner claims that my client didn't meet their side of the contract. I mean, frankly, we spent half the time arguing about contract, and to make it simple, Judge, this is really a civil action. Whether my client has a cause of action for the other side breaking the contract, breaking a moral, or vice versa, it's not really this court. I mean, essentially what happened is that the owner has used the state to prosecute a civil matter. And that's all I'm asking, Judge. I'm asking for fine, my fine, not.
Yeah, that would be the case if it wasn't for the defendant's own testimony today. The defendant acknowledged that she received the driver's text, she saw it and ignored it. That alone shows criminal intent to avoid payment on this case. If she had said, well, I never saw the text, but she acknowledged it, and that's why the criminal intent is here purposely and intentionally and knowingly, because she said, I refuse to acknowledge his text. That alone rises to the level of beyond a reasonable doubt that she had no intentions on paying the balance of this particular bill. Your Honor, it is clear with all the testimony, whether the driver showed up late, he testified he showed up on time, but that's irrelevant. What's relevant, Your Honor, is that she said, I saw the text and I ignored it. If she was concerned about the bus, she would have came out, told the driver, look, I don't like what you said or whatever, if there's something you said, she would have said, I think you need to call the owner. I'm unhappy with this. I don't like what was said about the driver. The bus was dirty, but no, Judge, her own admission, she said, I ignored it. That is criminal intent, Your Honor, and we ask the court to find her guilty.
All right, anything further?
No, Judge.
No, Your Honor. Based on the evidence and testimony in the case, I am going to find that Kiera White is guilty of theft of service. As such, is there a recommendation from the state?
Your Honor, we would ask, Your Honor, I'm sorry, just 1 second, Your Honor.
And I'm going to get to you also, Mr. Dodd.
Your Honor, unfortunately, this is not her first incident of theft. She had a theft by shoplifting in 2017. And based upon that, Your Honor, we would ask the court to sentence her 30 days in jail, $1,000 fine, and also require that restitution be paid to the bus company.
And the restitution I have is $461 based on the testimony?
That is correct.
Thank you. Mr. Dunn?
Your Honor, the court having found my client guilty, obviously the restitution is not an issue based on the court's ruling. My client is 25 years of age, Judge. She opted to have a trial because she was disputing, understanding and respecting the court's decision. I do not think jail is appropriate, honestly, Judge. I think a period of probation and restitution, perhaps community service is more appropriate in this case, Judge. Yeah, I mean, that's basically my request is I don't believe incarceration is the right message in this particular case under the circumstances.
Okay, I'm going to agree with you, Mr. Haddad, regarding that. If you'll stand, Ms. White, for the offensive theft of services, the court sentences you to 100 hours of community probation, 12 months on probation, 100 hours of community service, and payment of restitution in the amount of $461. Once you do that community service and pay that restitution, and the probation can terminate. Okay.
No, it's actually 465.
Oh, okay. I thought it was.
I don't dispute that, Judge. I think it is
465. Okay. 465. When I'm going to waive the probation fees for you while you're on probation, help you get to stay on your feet. And when you complete the terms of the probation, you pay the money back and you pay the money and you complete the 100 hours of community service, the probation's going to terminate. Okay. All right. Good luck to you.
All right. As far as paperwork, normal and a plea, there's something. Should I, since probation's, I don't believe is here, should I give her the contact information, contact probation?
Right. Normally what we do is we have them contacted within the first 48 hours. So do you have the contact information for probation? If not, Mr. Dowd, we can get it for you.
I'll, thank you. Litigation manager in my mind.
Excuse me, Judge Morrow?
Yes.
Yes. Can I just get the defense attorney to just state both his first and last name for me and spell it if he wouldn't mind?
Sure. Can you hear me now? Okay.
Yes.
My first name is Joanne. That's Juwayn, as in Nancy, Joanne. Last name is Haddad, H-A-D as in Delta, D as in Delta, D is in Delta. So 3 Ds, Haddad.
Okay, perfect. Thank you so much.
Did Jamel Dickerson come into court? All right, and Mr. Dickerson, you were a bit late for court today. You requested a bench trial the last time that you were here. Do you still desire to have a bench trial in this matter? Mr. Dickerson? Yeah.
Email address is your.
Oh,
Okay. Miss, what are you all doing with Mr. Dickerson's case?
Your Honor, the state is checking to see if a witness is here.
Okay.
He's here.
Excuse me, we need one of your names so we can get it.
Yes.
My name of the company.
Where the response is supposed to be paid.
Absolutely. I do my name again.
That's Robert Willis.
You got right, BRANDON. Okay, CKINNEY.
Don't phone number.
770-875. What is this gonna be like?
Probation needs to contact you.
Okay, 2903. No, 2903. That's it. I appreciate it.
Yeah. Your Honor, it appears that we are going to be ready on Robert Willis. Copy of that one as well.
Did Jessica and Yawa come into court?
No, Your Honor, the state will be asking for a bench warrant.
Okay, granted. So that leaves us with Mr. Willis and Mr. Dickerson. Do you all want to proceed with Mr. Willis first?
Yes, Judge.
Okay, so we'll hold.
Officer Carter.
Okay. And if Mr. Willis will.
We'll just answer that. Okay. Walk around to the fence. Why don't you go over to the court? Mr. Willis, how you doing?
My approach to,
Yes. Do you have a lawyer? Okay. Please just-
Judge, may I be excused?
Oh, yes. Have a good day. Good to see you.
Thank you. Good to
See you as always. All right, before we proceed with Mr. Willis, let me say that you have a right to remain silent. Anything that you say can be used against you. You have a right to have an attorney present at these proceedings. I know that you've been here before. I don't believe that you qualified for the assistance of a public defender and that you have not hired counsel in this matter. You understand that you do have a right to this bench trial. You also have a right to a jury trial. You have been charged with reckless conduct, discharge of a firearm near a public highway or street, and carrying a weapon without a valid license. Each of these charges carries a maximum penalty of 12 months in jail and a $1,000 fine. Are you sure that you do not want to try to get yourself some legal assistance to assist you in this matter before moving forward with this matter?
I took like gun etiquette class. Like I did that, but not as far as lawyer stuff like that. I got other stuff going on.
Okay, so you're gonna have to, I'm not understanding your response, Mr. Willis.
No,
No, you,
I don't have no lawyer, like stuff like that.
all right.
I just went on my own means and say I did like gun etiquette class.
Okay,
So
but they're
I'm
not,
gonna prove that.
they're not looking for a gun etiquette class,
I know.
Mr. Willis.
That's what I was gonna say though. I don't have no lawyer. You know.
May I ask the defendant some questions?
Yes, go ahead.
Yeah. So these charges are very serious and you have a right to have a lawyer represent. Can you hire a lawyer or do you prefer the services of a public defender?
I can't hire no lawyer.
I'm sorry.
No, they're not hiring a lawyer.
Would you like to get a lawyer for free? The state can give you a free lawyer.
He just said I can't qualify for a lawyer.
I believe normally before we bring them back, Mr. Patterson, they've already tried to qualify for a public defender and that they have not, they don't qualify. So,
And I think the court also has discretion if the court so wanted to appoint a public defender.
I do. Ms. Gant, you just happen to be the one that's here. I've got some other concerns besides the lawyer that I want to address prior to moving forward with this. And I don't, Ms. Gann, if you can assist me, I need to have possibly a social worker visit with Mr. Willis because I am not sure that based on what I've heard today, that he is understanding the ramifications of what could happen to him. So could you help facilitate that with the court? Okay, so what I'm gonna do, Mr. Willis, is that I am gonna put you in touch with the public defender and see how best to move forward with this case, okay? Because I think that you facing up to 3 years in jail on these charges is very significant. And I don't know that you really are comprehending that, okay? So if you could help the court with that, we're going to reschedule this for another time. We can.
It'll have to be in December.
And would you also, Ms. Gant, would you also redo his paperwork? To see if he might qualify for your services. And I know that we've done that in the past and I'm not, but since we have him here in person, maybe it'll be more effective. Okay, we appreciate that, Ms. Gann.
Thank you, Judge. I appreciate the court's consideration.
Yes. All right, Mr. Willis, your case is going to be rescheduled. Thank you. We appreciate you coming in. What's the reset date?
So we have a December 28th.
Let's go to January.
No, the victim is here.
Ms. Gann, our reset date is going to be January 25th, okay? All right, so I think that leaves Mr. Dickerson.
That is correct, Joe. just need Mr. Dickerson. I'm just going to be in trial, Mr. Dickerson. Not a problem. We did excuse the officer in this case, right?
Yes.
Okay, good.
Mr. Dickerson, can you come on up, please? Good afternoon, sir. You've been to court before, and when you were here before, you requested a bench trial in this matter. It's my understanding that you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings to represent you. It's my understanding that you did not qualify for the services of the public defender. Have you had an opportunity to try to get yourself private counsel? And do you want to move forward with this case without private counsel?
Yes, sir.
Yes.
Sir.
You want to move forward?
Yes, sir.
You understand that you've been charged in case 21 CR 000968F with battery. This charge has a maximum penalty of 12 months in jail and or $1,000 fine. So I'm not sure that that's the maximum penalty for the case. I'm not sure of anything on the case right now, but it's, you know, if you send it to the maximum, it's very significant regarding that matter. So you don't know what you don't know, which means that you don't know the rules of evidence. Probably you don't know, anything of that nature. So if you represent yourself, you might be severely limited with your defense. You do not have to testify in this matter. You can testify if you want to, but that's not something that you have to do. It's up to the state to prove that you are guilty of this violation beyond a reasonable doubt. So they have the burden of proving it. But if they prove their case, then the punishment for you could be significant. So given that, do you want to see if you can hire counsel, or
Yes, sir.
you would like another opportunity to hire counsel?
Yes, sir.
Okay. Is there any objection?
No, Judge.
From the state of All right, so I'm going to give you that opportunity to hire counsel, Mr. Dickerson. That will, I'm also going to reschedule your case till, is it January 28th?
25th.
25th?
Let me just confirm.
Okay. I'm going to reschedule your case until January 25th, which is, a number of months away, to see if you can get somebody to represent you, okay?
Yes, sir.
All right, you have any questions for me?
No, sir.
No?
Sir.
Okay, so you'll get notice for January 25th, so work on getting yourself some counsel, all right?
Yes, sir.
All right, good luck to you, sir. Killing me with that. This afternoon's bench trial calendar.
Yes, Your Honor.
Okay, all right, thank you all. We appreciate it. Good to see you in person.
Good to see you in person.
Thank you, Ms. Greenhouse. We appreciate it.
Thank you, Judge Morrow. Have a good afternoon.
You know, that was all my business with the court.
Yep, good to see you, Mr. Patterson, as always.
Everybody as well.
We'll see you next time.